চক্রবর্তী বাবু।
My lord, may I be permitted to mention one restoration application, my lord? Restoration application.
Give the slip. Hand over the slips.
In application. Contempt application.
All applications, please give.
My lord, may I probably mention
Just a moment, just a moment. All application first hand over.
application?
Yes.
My lord, may I leave to mention that lordship was pleased to give us, to remind your lordship that if these matters for the junior primary, that regarding hearing is regarding pending, so my lord was, earlier occasion was pleased to allow.
Cannot be done after a prior.
Oh, my lord, we are only appealing to your lordship. Let the matter appear. We are not, I know, my lord, lordship already hearing.
Here after vacation.
My lord, may I permit to mention
Just
item?
My lord, kindly give that.
My lord, may
How
I be
many matters are there, Mr.
My lord, there are total 32 matters. My lord, I'm grateful, your lordship.
My lord, may I permit to mention item number 311 to hearing, my lord?
Just a moment. First out of list
My lord.
mention.
My lord, may I be permitted to mention one matter?
Any other application?
On assigned applications, my lord.
Assigned?
Assigned before lordship. Lord, one group 6 matter, my lord, it has been assigned before your lordship. In your,
Group 6 what matters, sir?
my lord, with regard to the promotion, my lord, it has been released by the earlier bench, my lord, it has been assigned to your lordship. My
Has been assigned.
lord.
Very recently.
1 month back, my lord.
My lord, may I be permitted to mention?
Just a moment. Applications, all slips, please hand
This is
over.
my application, contempt application, my lord. It is released by the Honorable Justice, my lord, Harish Tandon and Sampadatto Pal, my lord, due to determination.
Sir,
Yes, my lord.
contempt was
Contempt was passed by the Honorable Justice Girish Chandra Gupta and Asar Arora, my lord. At the time, my lord, the order was passed. Thereafter, it was heard by the Honorable Justice, my lord, Harish Tandon and Justice Sampadatto Pal. Thereafter, due to determination, he has the bench has released.
My lord,
The order I annexed.
permitted to mention this contempt matter of 2019, my lord. Contempt matter of 2019. My lord, heard the matter, my lord, may I be permitted to mention in regard to the matter which was heard by my lord last on 20th February. There was a direction the matter will appear on within 3 weeks, my lord, not appearing in the list. I am for the respondent number 1 writ petitioner.
who is the petitioner here?
Dr. Shatanu Patro is appearing for the appellant.
Pardon?
Shatanu Patro is appearing for the.
Who is there?
My lord, may I be?
Is it hearing?
Yes, ma'am.
Is it hearing?
No. Application. Last heard on 20th February.
Yes.
My lord, may I be permitted to mention, my lord, WPCT number 241 of 2006. This is pending for 8 years, my lord. Kindly let it be.
Hearing matter?
Yes, my lord.
Hearing matter.
For
this
inclusion in the list, my lord.
combined list of June. দিয়ে দাও।
My lord, may I permit to mention item number 311, group 2 hearing matter. My lord, writ petitioner is getting half of his pension, my lord.
311.
State filed the appeal. My lord,
State's appeal.
State filed the appeal, my lord. I am for the writ petitioner, my lord.
Who is for the state?
For the state now, presently, Tapoti,
Give a notice and come back. It cannot be done this month. You
I
mention
am giving notice today. I am giving notice.
notice and mention next month so that we can upgrade. This month there are 2 more weeks.
My lord, I crave leave to mention for upgradation, my lord, to 205 to 210, my lord.
105. What are these matters?
This matter is regarding appointment to the post of Group D, my lord.
Madam, wait for some time because it is not possible. You remind us when the next month we see.
Yes, my lord. I third time I am mentioning this matter. My lord heard this matter on 12th March 2024. Issue is my lord seniority and promotion. All along there is a stay order, but when the matter is dismissed by the tribunal, my stay order also vacated. Now they have been issued a list of promotion order eligible candidate. All are the junior to the petitioner. My lord said, if you mention, to my lord upgrade the matter, my lord.
Matter is it?
My lord, that is appearing at serial number, my lord, 190 of the monthly list, my lord. This is the I have order, although I have annex.
This is motion stage.
Yes, no motion, no. My lord, admit the matter, my lord. Remind me.
Admitted, Mr. Chatterjee, wait for this month. It cannot be done this
My lord,
Remind
they
us
have already issued the promotion order. All the juniors, my lord.
You
Put the
take
entire
appro-
division.
Take appropriate steps, Mr. Chatterjee.
Well, this matter is
We
pending.
cannot- Already remind us next month. Yes,
Lord, may I kindly mention one pension matter, very small matter. It is pending since 2018.
you are for the petitioner.
I am for the petitioner.
Yes,
My lord, I beg to mention one hearing WPST matter of 2022, my lord. In the first week of March, my lord directed to exchange of affidavits that are done, my lord.
June monthly list. Yes,
I am grateful.
Your Lordship, I am permitted to mention 3 contempt matter that has been specially assigned before your Lordship. The matter is running in 227 to 232 of the monthly list, your Lordship, for upgradation. 227 to 232 of the monthly list. Sorry, for 427 to 432. Apologies, your Lordship.
whose order was it?
Your Lordship,
Which court's order was it? You haven't seen the matter also. Check up the file and come and mention. Yes, yes.
Lord, land loser matters, your lordship said that the other bench is hearing the contempt matter. Rule issued, they are about to give appointment to all, my lord. Your lordship can dispose of all these matters, my lord. Your lordship told me to mention it after the
What rule issue?
rule issue in the contempt petition, where they did not want to give appointment because of overage.
What did we say in this matter? These matters have
No.
never appeared.
No, they appeared. Your lordship said, let the other bench hear the
Let
matter.
it be finished, then you may
My lord,
remind us.
otherwise, my
Yes.
lord, the land loser matters remain pending day after, my lord, 12 years gone by.
What can be done? This is
No,
not
if
for
your
the
lordship-
bench to consider.
I'm only saying this.
You are blaming the court.
No, I'm not saying so.
Your land
The
users have
authorities,
matters
my
for
lord, the
that we are
authorities
not-
have done.
that you wait for your
Lord,
chance.
may I just beseech your lordship to list the matters on some day, and so that the matter can be taken up. It will hardly take 5 minutes.
Discriminatory matters cannot be listed. Mr.
My lord, all the land loser matters are there before my lord.
Yes, those will appear in each
So
term.
therefore, my lord, I'm giving the slip so that,
Give the slip.
and the order of the other court, my lord, also.
We are not concerned with that.
Well, at item number
I'm
three, item number 309 of today's list. Well, at 2 months back with notice, I mentioned this matter. Well, I am not getting the salary for last 4-5 months. Now, Vishwabharati has preferred the appeal because of the appeal. The
Bhattacharya, remind us next month.
I tell your lordship, this
Cannot be done within these 2 weeks. Mr.
well, I'm only for 1 minute. Well, your lordship requested me to give the slip with the urgency. Well, I gave the slip. It was noted by your lordship's officer in red ink that the matter will be posted in the supplementaries, which was the desire of your lordship. Because I have filed an application as I am not getting a salary for last 6 months.
You have filed an application.
In connection with this,
Where is the application?
well, it is not appearing. Well,
The application number we will.
I have mentioned, I have given for last 2 months, the matter is not listing before, is being not been listed before your lordship. But I don't know what is the reason behind. The file has been segregated in red ink, but it has been marked that matter will be listed.
You had the avenue to see what marking.
Well, I have seen the file when it was segregated. It was done by the court officer. Well, what I am saying is right.
তুমি কি ওনাদেরকে আমাদের মার্ক করা স্লিপ
No. The officers.
Don't make stray allegations. We are completely aware of what are matters. This is the court where nothing, what we have said, that is done.
But I know.
It is checked by us. Urgency is ascertained, and then we ask our court officer to put it in the list.
Lordship.
If you make this sort of suppositions that there was a rating, That is meaning that matter was allowed and was to be listed. This is an allegation you are making.
My lord, I am not alleging anybody.
Then
My
what
lord, I am
more
not
is
making allegation against anybody. My lord, I am.
What more is left?
My lord,
What more is
my lord,
left?
the matter is not being listed for last 2 months. Can you see is my condition? Every day, my lord, a person is not getting.
When did you mention?
My lord, 2 months back, my lord was not there. My lord was not there for a considerable time. Now, my lord, we approached your lordship's officer. My lord, he said that as my lord is not there, it will be listed.
Yes.
My lord,
We have taken up our seat. You are mentioning. We will look into it.
my lord, grateful. I'm grateful. I have
Where
no
is
other
your
point.
mentioning?
My lord, 2 months back, I have
You give one. What we don't know. You give a fresh mentioning slip.
very
Which
well.
matter you are mentioning?
By today itself, I'll.
Yes.
Honorable Trial Court directed the Appellant University for pension fund. Urgency is that petitioner already served notice
Come
contact of
next
university.
month, madam.
My
Come
lord,
next
my lord, may I be
Yes.
permitted to mention, my lord, these are the land loser matters, my lord, heard on 13th of February.
Give the slips. Land users গুলোকে আলাদা
না, আমার একটা ডেট ফিক্স করার ব্যাপার আছে,
See.
তাই জন্য ডিস্টার্ব করি।
My lord, it was appeared.
Why don't you hand over in the morning? We said all new motions and applications and
My lord, the appellant hearing is not allowed to participate in the counseling process of NEET UG 2024 under EWS category, my lord.
yes. So
My lord, the petition is suffering, my lord, for inclusion, my lord.
what? It is a new matter.
Yes, my lord, no matter.
Give
Restoration, my lord. Restoration.
restoration. It will take.
My lord, I discussed with all the other councils. 21st 2 p.m. everyone is available.
21st 2 p.m. Yes. All the list.
Yes.
You approach me, Lord. I'm saying only not to the Lord.
Monthly
Tomorrow,
list
day
of
after
July.
tomorrow,
Monthly list of July. Yes. Next matter.
তাহলে সুবিধা হবে।
ফাইলটা কোথায়? ফাইলটা কোথায় দেখো? একটু দাঁড়াও, ফাইলটা দাও। ওনার নাম নাও। কে মেনশন করলো? ইয়েস স্যার। কল হিম প্লিজ। ইয়েস কাম। An adjournment. Give your name. Yes. Item number 1, you were there. You Mr. Goswami. Mr. Goswami. An adjournment has been put on behalf of release the matter under meeting the combined monthly list. To dismiss will be an adjournment has been paid for on behalf of the petitioners. Stop. As a last chance, the matter stands adjourned. Stop. Please the matter. Under the same head, the combined monthly list of
Much.
ওটা ফার্স্ট করছি একটা।
You were there, respondent. With the appearance there.
Much.
Oh, my lord, for the respondent, I am paying for password. My
I am for the petitioner, my lord. This is the affidavit of service. Lord, my prayer for compassionate appointment, my lord, refused, my lord. On the ground, my lord, I have not stated, my lord, the application of the compassionate appointment, my lord, in not in a proper basis and also giving a suppression of material facts, my lord. On this ground, my lord, my prayer turned down, my lord.
My lord, I am paying for short password.
Although, my lord, the department asked me to file proper family chart, my lord. Second time, I have also furnished, my lord. Initially, my lord, I could not be able, my lord.
Yes, what is your case, sir? 2001 was the date. There was a dispute as regards your family composition.
Yes, my lord.
Then which order was impugning the original application?
My lord, the order, my lord, 10/11/2018, my lord.
So why they are saying that the declaration was contradictory?
My lord, initial declaration what I have made, my lord, I am born out of second wedlock, my lord, and I furnish the detail as per the second wedlock, one sister, the divorcee, and my name, because the second marriage was also dissolved, my lord. Second marriage was also dissolved, my lord.
Whose second marriage?
My lord, the deceased second marriage.
Yes,
Deceased
you are the
second
son of Chaya.
son of Chaya, second marriage.
Very, very good.
That portion of details.
But you did not declare who were the heirs out of the first marriage.
Yes, my lord. That they have asked me to declare once again to furnish all the family members. Thereafter, my lord, on affidavit, I have furnished all the details of the family members, my lord. My prayer rejected on the ground that I have suppressed the material facts because I have not furnished the details of the first legal heirs.
That is a fact.
That is the fact, my lord. I cannot change the fact.
2001, you made a wrong declaration.
My lord, I bow down before your lordship. I made a wrong declaration, my lord, that I cannot change the fact. But, my lord, on the other hand, my lord, second time I have furnished all the details.
When was the second time? Show us when was your first declaration, when was your second declaration, and where is the impugned order, which you challenged before the learned tribe.
My lord, the first declaration, my lord.
Got 1/5 of the terminal benefits. You got?
Yes, my lord. Because I have preferred as title suit, my lord, and title suit, my lord, decreed that I have eligible to get the terminal benefit.
Who was the order which you challenged before the tribunal?
My lord, the first, my lord, may I place, my lord, the first affidavit, my lord, once, my lord.
No, first was the order by which it was rejected. Now what remains? 2001 was the date.
Yes,
we are in 2024. What is your age now?
Lord, age, my lord, I have to ascertain, my lord, the age, my lord. I have to ascertain what is
Where
the
is the order by which your
page?
You are not ready.
My lord, I am ready, my lord, I am ready, my lord. I am ready. My lord, the annexure page is missing, my lord, from my. My lord, page 174. Page 174.
174. 74 also. So
Lord,
this is what you challenge before the tribunal.
My lord, may I read the order, my lord?
Yes.
Subject compliance with the order of the Honorable CAT, Kolkata Bench. Honorable CAT, Kolkata Bench, order dated 27th of September, passed in way such and such. In compliance with the judgment dated 27th September 2018, passed by the Honorable CAT, Kolkata Bench in way 739 of 2018, in the case of Sanjeev Kumar Das, and has duly been considered. It is seen from the record that Sri Sanjeev Das, son of second wife of the deceased employee, applied for compassionate appointment and submitted a notary affidavit dated 7/3/2017, along with the self-declaration where Srimati Chaya Das, second wife of the deceased employee, was shown as a widow and family member of the deceased employee. Accordingly, the score point was awarded and his case was placed before the appropriate committee for the purpose. Afterward, it is found that the marriage between late Sharoj Kumar Das and Srimati Chaya Das was dissolved on 19 December 1989. Late Sharoj Kumar Das has two sons and two daughters. from the two wives, but Sri Sanjeev Kumar Das only mentioned himself as and his sister as family members of his notary affidavit dated 7/3/2017. Subsequently, another spot verification was made to clear the anomaly, and then Sri Sanjeev Kumar Das submitted another notary affidavit dated 2nd March 2018, wherein he gave the names of all the family members. As Sri Sanjeev Kumar,
17 years after the death. 17 years after the death.
Lord, it was not considered thereafter representation sent.
Alright, please.
As Sri Sanjeev Kumar Das submitted false information via his notary affidavit dated 7th March 2017 to deprive other family members of the deceased employee, the competent authority has decided to cancel his candidature. The decision of the management was intimated to him via this office letter dated such and such. Accordingly, the representation of the Sri Sanjeev Kumar Das dated 6th May 2018 is disposed of. That order I have challenged before the.
What is the wrong in this order according to you?
I maybe give the wrong details that I cannot change but whatever after spot in verification they have asked me to furnish all the details
That is because they ascertained that you have made a false declaration.
Because
it wouldn't have come to their notice had they not conducted the spot inquiry to show what is the wrong in the order. When was your first declaration? That was in 2017.
Yes, 7th March 2017.
So your father expired in 2001.
2001.
So did you not file any application immediately?
Because there was a dispute. Yes, I have filed application. When I have filed, the date is
you filed it on 24th of January 2001.
24th of January 2001.
Yeah,
immediately upon the demise of the ex-employee, the applicant had on 24th of January 2001 requested the office of the respondent number 3 seeking service as well as death benefits. In the said application, the applicant had disclosed that the ex-employee had only left behind the applicant and his married sister Sangita Roy, and that he followed up the 27th of 2021.
Yeah, that is at page. Where is your application?
May I first furnish the first application, Because there was a dispute between the family members, I could not establish my right
Sir,
title.
you are for compassionate appointment.
Yes,
Other had expired in 2001. Admittedly, your application, this application for getting, sir, this is your first representation.
Yes,
Page 68.
Yes, 68.
Page 68, na?
Application for getting service and other benefits of the deceased employee Sharoj Das of first department token.
So thereafter you did not take any steps.
Thereafter
filed a civil suit.
I filed a civil suit. The final reply 22nd of just after that page 70 22nd of August 2001 in continuation of this service, this office letter such and such, it is informed you that registered letter number such and such for rupees Koshipur post office has been delivered and the address they have sent and again I have made representation on 14th January 14th January also one representation 14th January 2002.
Where is that page?
Page 72.
70?
Page 72. 72.
72.
2. Under instruction from and on behalf of my client that the father of my said client, late Sharoj Kumar Das, such and such, died in harness such and such. Soon after the death, Sharoj Kumar Das, terminal paying share of terminal benefit of his father as one of the legal heirs of the said disease, such as DCRG, GR fund, such and such, leave salary and other service family pension to the authority concerned. And lastly, on 3rd December 2001, to start the family pension of his favor, but your authority concerned staff employee. This is regard to pension and terminal benefits. Thereafter, I filed a suit. Immediately after the suit, I got a decree, that I am been entitled to get the 1/5 share of the terminal benefit,
Now kindly come, so your first declaration, that is the representation which you made 2017.
Yes, my lord. First declaration. Page 118, my lord. The
That
application,
was 7th of March 2017.
8th March 2017, my lord.
Page 100 and
Page 118, my lord. It was pending before the department, my lord. My case was not considered, my lord. Along with the affidavit also, my lord.
Twenty-first of February. So you disclosed during such 21st of February 2018, he decided to disclose the dependent. Very February 2018.
Page 147, my lord.
147.
Yes, my lord. Page 147.
And where is this 12th February letter?
12th February.
There was a spot wedding.
Yes, my lord. It is intimated that the spot verification at your above residence will be carried out on such and such in connection with assessment your eligibility for compassionate employment in this factory. You are requested to keep ready the photo identity, Aadhaar card, such and such.
So now page 151, you get the new declaration.
Yes, madam.
So this is a clear case of suppression, sir.
My lord, I bow down before your lordship, my lord. I have
How
suppressed.
can we help you? Tell us.
Because, my lord, I cannot change the scenario, my lord. At this stage, I cannot change the scenario, my lord.
Like, you know.
বলে দিয়েছি বলেছি Ordinance Factory Code. Gun and Cell Factory. ঠিক আছে হ্যাঁ মিনিস্ট্রি অফ ডিফেন্স গভর্নমেন্ট অফ ইন্ডিয়া Washington. Factory. Direct in
14th. Medical type watch. After sparse white this is still and subsequent time of disease left behind some scientific the disease has one son, one son,
150 watt to the. What is the name of your sister?
Your this sister minute out of
You are Chaya's son and daughter.
higher son and daughter.
And Nirmala was the first one.
Nirmala, the mother of the deceased.
Hey, come to page 151.
51.
out of it halfway.
Yes, madam.
It is at one daughter and second out of
Second.
second word, no?
Chaya Das minute the second wife.
So first wife, one son, one daughter. Second wife, one son, one daughter.
Second wife. Well, after demise, there was a family feud regarding that.
এটা নারায়ণ দাস এটা প্রথম এটা সেকেন্ড ওয়ান এটা নির্মলা দাস অন্য সঙ্গীতা রায় সঙ্গীতা
And such dispute as such dispute led to civil suit being title suit number 80 of 2002. Title number 80 of 2002. Now, in 2015, a suit was declaring the petitioner to be entitled to 1/5 of the cardinal benefits of the agreement. In the meantime, the petitioner approached the respondent and requested for to grant appointment of compassionate initiative. At the time of application, petitioner submitted the affidavit mentioning itself and as legal heirs, and he omitted to disclose the particulars of other legal heirs in that thing. The same created a confusion and accordingly the respondent undertook an inquiry apart from which we this is other legal whose name was suppressed with the first degree. On the asked the petitioner submitted to another agreement disclosing the particulars of all legal to survive the disease. Survive the disease. Survive the petitioner case was case of fair for compassionate appointment was considered and was considered on several occasions. And ultimately, by order
Page 170.
by an order dated 10th 2018, the petitioner claim for compassionate appointment was negated on the accepted sharpened and the rules involved. The petitioner scored 40.440 out of 100, and there was no vacancy. There is no vacancy to happen. Agreed by the same order dated 10th November 2018, the petitioner puts the tribunal with the urgent application being way 350/175 after considering the limits of parties and the materials of the court before the by passing the order impugning the requisition, the original application was rejected, affirming the order, negating the petitioner's I have affirmed the order between the hence this initially the petitioner gives the names of all the legal heirs, but subsequently by filing the petitioner disclosed the legal heirs of all the disclosed the particulars of all the legal heirs after the system. It suggests that is a dispute of the family. Regarding the terminal benefits of the decision file, there was a feeling, but such feeling and cannot be attributed to the petitioner, and considering the fact that petitioner is required to view the situation for the compassion of employment, yes, that's it. And the direction between respondent, when you oppose such prayer, submit that the petitioner has used the material and at such length of time, it's difficult to give any direction. That's what we have about the petitioner. Here's some Distinctly, the petitioner and the deceased people died in harness in 14th January 2001. So, thereafter, regarding terminal benefits of the that is put gave rise to a civil suit, and the civil suit was disposed of in degree in 2015. The petitioner pair for compassionate abandonment was considered on several petitions, and as per the rules governing the case, the petitioners were 40 out of 100. And the reports stating that the petitioner or the family lived by the deceased employee that has survived without any employment assistance for almost 23 years. And I got further reveals that one of the sons of the deceased employee is in service, and other are living their matrimonial rights, conjugal right in their respective matrimonial services. So, after such a considerable period of time, the sense of immediacy stopped. The object the underlying object, the introduction of the scheme was grant of compassionate employment to bring to the community, which planted the penalty is sudden right on is solely with policy compassionate appointment cannot claim that in matter of right. And it also not be a right of inheritance in the life succession. In the given case, petitioner, in fact, the petitioner suppressed the materials and say the touch of the legal heirs for not to survive, but this is signified. That happened. Mainly survived without employment assistance for long 3 years. Having considered this fact and the scrutiny of the other who do not exclusively pretended to convince us that their petition is dismissed.
Yes, next.
May please issue. Madam for the petition.
The original applicant. But pursuant to your lordship, my lord, earlier direction.
কত করছি সেটা তুই আছি সেটা তুমি কি নাম
I'm sorry, my lord. I'm sorry. Sorry. Sorry, I'm charged.
Never mind. I am for the petitioner, madam.
Sorry, ma'am.
Yes,
My lord, before your lordship comes to the impugned order, my lord, kindly peruses the order at page 76 for a moment, my lord.
76.
6, my lord.
Yes.
Yes, my lord, kindly peruses at page 78, para 4, my lord.
Yes.
Accordingly, without entering into the merits of the case, we hereby direct the respondent number 1, namely the Secretary, Ministry of Women and Child Development, to pass a reasoned and speaking order in accordance with law within a period of 6 weeks from the date of receipt of this order.
This is for final hearing. Why it has come under the motion?
My lord, it has come because, my lord, there had been 2 speaking orders against the self-same order of the Honorable Tribunal, my lord. So, my lord, there is no provision for 2 parallel speaking orders against the self-same order, my lord. That is number 1. Number 2, my lord, there was a direction that the order will be passed by the respondent number 1. That is Secretary to the Ministry of Women and Child Development. But it has been actually issued by the Deputy Secretary, my lord. So that is why, my lord, there was a direction of the Honorable Coordinate Bench, my lord, dated, my lord, 22nd of March 2023, my lord. My lord, should I read the order, my lord?
22nd March.
Yes, my lord. Of the Honorable Coordinate Bench, my lord.
They were asked to produce the copies of the orders. There was a previous direction.
My lord, yes, my lord. They have produced certain documents, my lord. And there was a direction for from the department itself to produce a corrigendum PPO. But they have issued parallel PPO, my lord, which is highly irregular, my lord. There cannot be 2 parallel speaking orders against the self-same order of the Honorable Tribunal.
What was your grievance?
My lord, my grievance was that I have not been allowed the 3rd MSCP in the proper manner, my lord.
You have already returned.
Yes, my lord. I have returned in 2013.
So why it is appearing as motion?
My lord,
It has to be heard.
It has come from the tribunal, my lord.
Yes, there was a matter. You did not appear on 21st of March when the matter was taken up.
My lord, unfortunately, I missed them for a few moments, my lord.
You have the reply rejoinder has been annexed
Yes,
here.
reply rejoinder is
for hearing.
Yes, my lord.
Note sheet. Mr. Roy, why you were asked to produce the note sheet?
But in fact, my learned friend took a point that the reasoned order which was passed earlier in terms of the order passed by the learned tribunal was not by the competent authority. Now, the tribunal has recorded that the order which was signed by the concerned officer was supported by the authority who was directed to pass the order. That is finding of the tribunal. Now, the coordinate bench, the honorable coordinate bench of this honorable court, directed me to produce the note sheet of the department so that it could be ascertained that the order was passed by the competent authority. That's why the documents
produced.
Yes, I have produced.
You have got it here.
Yes, that is there.
Note sheet.
Note sheet that was produced. That is possibly with the record.
That is not recorded here. That
recorded. Well, that is recorded.
Oh,
Yes, my lord, that is recorded, my lord. Kindly.
Where is the note sheet then?
kindly peruses the order dated 19th of June,
No, no.
23, my lord.
Pursuant to the court's order, is this the note sheet?
Yes.
So you bring it by means of a supplementary evidence.
That was handed up before the Honorable Coordinate Bench, my lord. Not by way of supplementary affidavit.
This has to be on record, na? He has to get a copy of that.
He has received.
Yes, my
He has-
lord.
Lord, he is only grievance, Lord, this is, I'm subject to your lordship's kind consideration. Lord, his client is only aggrieved by the non-grant of MACP benefit. Now, Lord, the point which was raised, the reasoned order, Lord, has declined to grant the benefit which was sought for. Now, Lord, only point which is to be decided by your lordship, whether the petitioner is at all entitled to the benefit of MACP, third MACP benefit or not. Lord, the other things are all technical. Lord, whether it was
So why we shall decide? It is a fresh cause of action to be decided by the tribunal.
no, Lord, he approached the learned tribunal. The learned tribunal has also declined to grant any relief. Therefore, he is aggrieved and has come before your lordship.
No, my lord, may I add a point? My lord, I approach the Honorable Tribunal. Honorable Tribunal has directed them to consider my case in terms of Honorable Principal Bench order, Honorable.
Where is that order?
My lord, that is at page 77, my lord.
Will kindly see the last page of the order
Which
of
order
the tribunal.
You are challenging the tribunal's order. You are not challenging the tribunal's order.
Yes.
Where is the your prayer is not there?
My lord,
Where is your you have challenged 9th of November 2022 order?
You
have not challenged the tribunal order.
Yes, my lord.
So,
That is the issue.
so from your prayer.
আপনি চ্যালেঞ্জ করেননি অর্ডারটা।
At page 17, my lord.
You did it. We have already read it.
He needs.
We have already read it.
My lord.
Where is the challenge?
He has challenged the speaking order.
And you have only prayed for an ad interim order in G, not to give effect, further effect to purported order of tribunal. What ad interim order? Tribunal has already by this order relegated for consideration.
My lord, kindly peruses para D, my lord.
So we will peruse later. Please come to your page 19.
Page
19.
Yes, my lord.
So what you are praying an ad interim order in terms of prayer C and D.
Yes, my lord.
Not to give effect to the purported order of the tribunal of 9th of November. 9th of November, on the basis of that direction, they pass those two orders.
No.
Just
the speaking order, both the speaking orders were challenged before the learned tribunal. In 9th November 22's order, have
where is that order?
That is last annexure
at page 157. Man.
He challenged both the
speaking order, and the tribunal did not interfere with the speaking order. The OA was dismissed. If your lordship kindly see the last page of the order, which is not impugned, he needs to file a supplementary affidavit, Lord.
No.
Page 14, internal page 14 of the tribunal's order. Paragraph 12.
So, Mr. Das, you have not challenged the tribunal's order.
My lord, that is my case.
That is not reflected in your petition.
আপনি সাপ্লিমেন্টারি ফাইল করে দিন না, কেন ও এর অর্ডারটা চ্যালেঞ্জ করেননি আপনি প্রেয়ারে, আপনি স্পিকিং অর্ডার গুলো চ্যালেঞ্জ করেছেন আর এমএসিবি বেনিফিট চেয়েছে, কিন্তু ও এর অর্ডারটা চ্যালেঞ্জ করেন।
And this matter appeared before coordinate benches. You did not point out also.
Yes, my lord. My lord, order is there, my lord.
Better let him file a supplement subject to let him file a supplementary affidavit challenging the impugned order. He has questioned the propriety of the reasoned order.
If you have questioned the propriety of the reasoned order, that is to go back to the tribunal.
Yes.
Your grievances, tribunal did not set aside the impugned orders.
Yes, my lord.
So this order ought to have been the subject matter of challenge.
9th নভেম্বরের অর্ডারটা চ্যালেঞ্জ করেননি আপনি রিটে, ওইটা একটু করা উচিত ছিল।
Check up your brief and come. Take necessary steps. Yes, not today. Next.
Lord, if your lordship,
Mr. Das learned advocate appearing for the petitioner. Prays for an accommodation to take appropriate steps. Pursuant to the earlier order of this court, একটু দাও তো। Let the in view thereof, let the matter go out of the list for the present, stop liberty to mention. Yes, next.
I am grateful to you. আপনি স্টেপ নেবেন প্রপার যেগুলো করার, সাপ্লিমেন্টারি ফাইল করুন, এখন আউট অফ লিস্ট করে লিবার্টি টু মেনশন।
My position. Now for the petition. But pursuant to the leave granted by the Honorable Court, my lord, earlier, but I am, my lord, filing this supplementary affidavit, my lord, annexing the reply and rejoinder of the tribunal, which, my lord, I stated in my writ petition that I annexed, but mistakenly I did not. My lord, here before your lordship, my lord, the petitioner who has, my lord, applied for a Group D post through the Railway Recruitment Council, RRC. So, my lord, the petitioner, my lord, appeared, my lord, for the Group D post, my lord, of the examination of the RRC of the railways. So, my lord, what happens, my lord? He passed in the written examination, and thereafter, my lord, he also, my lord, PET, he also qualified the physical endurance test. And thereafter, my lord, at the time of document verification, my lord, he went, but his file of the original documents went missing. So he, my lord, lodges a GDE to the concerned police station. And
we will hear it, Mr. Roy. There is no scope for any.
No, there is no scope, my lord. Only one thing, my lord, I was just praying before your lordship that
We are including in the next combined list for hearing. Asho, Mr. Roy learned advocate.
my lord, may I just indicate only one prayer, my lord?
Has brought on record the pleadings exchanged by the parties before the learned tribunal by filing a supplementary evidence. Stop. Let such supplementary. You have got a copy.
Yes.
Let the said supplementary affidavit be kept on record. Stop. Upon hearing the learned advocate, Mr. Banerjee learned advocate enters appearance on behalf of the
Railway Authority.
Railway Authority. Stop. Upon hearing the learned advocates and considering the materials on record, we do not find any scope towards issuance of any interim order. Stop. As all the pleadings exchanged by the parties before the learned tribunal are already on record, comma, list the matter for final hearing in the combined monthly list of June 2020. Yes, next.
My lord, under the heading, my lord, because my lord, here, my lord, the recruitment process, though, my lord, was concluded long back, my lord, by the order of the Honorable Court, my lord, it is still continuing, my lord. And I just beseech your lordship that What happens here, my lord, very small point is involved that they said that they,
We will hear it next month. Mr.
if it could be, my lord, subject to your lordship convenience, any hearing, any heading, my lord, other than hearing, my lord, subject to your lordship
Mention
convenience.
before us. Yes, next.
As your lordship please. Grateful.
You are praying for a substituted interim order. That's চলো, মুসাই নেই। শুধু মুসাই নেই। Yes, Mr. Banerjee, we keep it under the same heading.
Great.
As your lordship.
Kindly, my lord.
Release the matter for final hearing under the same heading in the combined monthly list of June.
Great. Grateful.
Yes, next.
Item 5, my lord, I beg to appear for the petitioner. My lord, in this matter, my lord, agreed by the order dated 9th of February 2000, my lord, 23, my lord, the petitioner preferred this application, your lordship. Initially, your lordship, the petitioner was, lordship, may I hand over the affairs service. The petitioner was appointed, your lordship, for your lordship Group D trackman in Eastern Railway, your lordship. After performing 3 days service, your lordship, the petitioner was served with a notice intimating him to, my lord, again gone through the medical examination. Although he was appointed, your lordship, after physical efficiency test and other tests, your lordship. Having such notice, your lordship, the petitioner approached the authority for his examination, and he also, your lordship, collected medical certificates from Dumka hospital, your lordship, submitted those documents, your lordship, but the authority did not turn up, your lordship.
Authority?
The authority did not turn up. They were not listen anything to the petitioner, your lordship. Due to such inaction, the petitioner prefer one application before the Central Administrative Tribunal for a direction upon the authority to, your lordship, to consider his candidature for that post, your lordship.
That you said you were appointed.
I was appointed. I worked for 3 days. That is admitted, your lordship. Provisionally appointed, your lordship. Provisionally.
Prior to medical examination.
Prior to, your lordship.
Medical examination.
Page 44, my lord. Page 44 of my application, my lord. Page 44. This is the application of the, this is the letter of the authority. Page 44. Appointment in the category of temporary trackman in engineering department. Thereafter, your lordship, page 49, annexure P7 is the letter issued by the assistant personnel officer to the petitioner asking him for that they have detected possibility and error of judgment in the decision of the first medical authority. Page 49, my lord.
No, what page 44 was it? What is it?
Page 44 is the provisional appointment letter issued by the authority to the petitioner in the post of temporary trackman.
In the post of
Temporary trackman in engineering department.
temporary. Very good. Then page
Then the
47.
page 47, your lordship, the office order, your lordship.
Yes.
Serial number 2 is the name appearing, name of the petitioner is appearing, my lord.
This was on 11th of September.
11th of September 2012, your lord.
The appointment was in April.
No, my lord, thereafter I appointed.
No, 17th April you were provisionally appointed.
17th April, this letter issued to the petitioner. Letter issued to the petitioner. Thereafter, one official order was issued, your lordship. 17th April, the authority issued this letter to the petitioner that yes, you are provisionally appointed. But the final order was, final office order was published on 11th of September 2012.
This was subject to verification of documents, character and decision, however even that is subject. No, prior to this your medical test was done?
Done, your lordship. Medical efficiency test done.
Where do we find that?
My lord,
Where do we find that?
Lord, this is the procedure.
Who was the recent order which you challenged?
49.
Now kindly page 49. What is this?
Page 49.
Medical examination you were called.
Page 49, Your Lordship. Page 49 is the letter issued to the petitioner that they have found error of judgment in the decision of first medical authority.
You may produce medical certificate in terms of such and such.
Although this medical authority
About the possibility no, we don't understand. Was there any medical test?
Lordship,
You were successful in that.
I have successfully gone through that, Your Lordship. That is medical.
Was the order which you challenged before the tribunal?
Before the tribunal, we have challenged, my lord, the order at page
73.
73, Your Lordship. Page 73.
From that we will find the reason.
That page 73 order was passed, Your Lordship, on the basis of the
Earlier order of tribe.
earlier order as well as the, Your Lordship, the report of the medical board. Report of the medical board, Your Lordship, at page 60, Your Lordship. Prior to that, kindly.
60.
60, Your Lordship.
Page 55 to earlier on. 60 কোথায় পাচ্ছ?
Pursuant to the order of the tribunal,
Yes, yes.
the authority, after prolonged period, they have examined the petitioner in the year 2016 and they have detected at, may I read, Your Lordship? They have detected diabetic.
So this you challenged before the tribunal.
Before the tribunal.
So what did the tribunal say?
The tribunal affirmed the order passed by the authority, Your Lordship, solely relying on the affidavit in opposition filed by the authority, Your Lordship. The authority in their opposition, Your Lordship, suppress the material fact that they have, Your Lordship, in the same category, Your
It
Lordship.
has to be hard, sir. There is no scope for it.
But Lordship, kindly consider, Your Lordship, 2012 the petitioner appointed. 2016 the same authority, Your Lordship, conducted medical test and detected diabetic, Your Lordship.
No, you were found unfit in all categories.
My lord, kindly have a look there on, Your Lordship, the medical certificate issued by their medical board, Your Lordship.
Yes, that is page 40.
Lordship, not for all post, Your Lordship, only for that particular post because of detection of diabetic, Your Lordship.
Thereafter, on two occasions, medical examination.
My lord, I prior to that, Your Lordship, from another medical hospital, I, Your Lordship, gone through in my own, Your Lordship, for medical examination and submitted those documents before the authority, Your Lordship. They have not considered those certificates.
Not binding up.
Have you annexed their reply rejoined here?
Yes, Lordship. I have.
Same order. upon hearing the learned advocates and considering the materials on record, we do not find any scope towards issuance of any interim order. So we have been informed that the pleadings exchanged by the parties have already been annexed to the present application. So in view thereof, please the matter for final hearing under the same heading in the combined monthly list of June.
Well, item 6, your lordship, I appear for the petitioner. The instant petition, my lord, is subjected against, my lord, the order as passed by the, my lord, Central Administrative Tribunal on your lordship 22nd March 2023, thereby rejecting my application, my lord, for appointment in die in harness category. On the ground that
Just give us 2 minutes.
my lord, may I hand over the affidavit of service, your lordship? It has been served upon all. Really? Confused.
Yes.
Yes.
Date of date, what was the system prevailing?
My lord, on the date of death, my lord, the merit point system was not prevalent.
Then which system was prevailing? Show us the circular of the merit point system that all cases have been brought under the purview of the scheme.
Your Lordship, this application, the date of death was 10th of November 2009. He filed his application on 15th of February 2010.
Yeah. 10th of February.
10th of November 2009
was the date.
No, my lord, the death certificate says, my lord, 2nd November 2009.
2nd November 2009.
Hold it. 2nd November 2009.
9.
An application made on 15th of February.
5th February
5th
2010.
February 2010. And thereafter, the application was defective. So at page 66, we raised and we gave a letter to them stating that These are the this application is defective, which is on 24th October 2011, page 66.
66.
Your Lordship.
24th October.
P3.
Yes.
24th October 2011. Your Lordship, the GDS, that is Gramin Dak Sakes scheme came on effect on 1st of January 2011.
Where do we get it?
Your Lordship, that is in para 10. It has been stated.
First of, with effect from 1st of January 2011.
Your Lordship.
So how does he come under the purview of this scheme?
Your Lordship, because his application, when we were considering, his application was defective. And after the defects were cleared, when his application was being considered on that day, this GDS was applicable, Your Lordship.
When did he apply after this rectification?
Your Lordship, after the rectification.
My lord, firstly, I applied on 5th of February 2010. Thereafter, my lord, by a document, your lordship dated 24th October 2011, few documents have been asked for from me, my lord, which my learned friend has just shown to your lordship at page 66. In compliance to that letter, immediately, my lord, I have served all the documents upon my lord the respondent.
January 2000.
Thereafter, my lord, I have made.
When did you file?
Page 67.
67, your lordship.
16th January 2012.
12.
By that time, the scheme
came in effect.
Yes, by that time the scheme came into effect, and thereafter, my lord, the scheme was abolished in total, my lord, on my lord 30th May 2017. And after that, my case, my lord, was again reviewed in the year 2021. At that point of time, my lord, the scheme was not in force. In spite of that,
reviewed. No, it was your review application was.
Yes, my lord, reviewed
on 27th October 2021. Currently come to paragraph 10 of the judgment.
My lord, review committee held on 27th October 21. Yes, my lord, as on that date, the merit point system was not in force because it got abolished prior to that in 2017 only. My lord, on your lordship on 30th May 2017, at page 95, your lordship will find that.
Review was under which provision?
My lord, review was, your lordship,
Date was in 2009.
Yes, your
You
lordship.
applied on 5th February 2010.
10.
Your argument that it should be considered in terms of the scheme which was prevalent at the time of death, that was accepted by the tribe.
No, my lord, that was not accepted by the tribunal.
Paragraph 9.
Yes, my lord, on the contrary, the
Read paragraph 9 first.
in view of the above judgment, it is now settled principle of law that the norms that prevailed on the date of consideration of the application should be the basis of the consideration of the claim for appointment on the compassionate ground.
Right.
Here, your lordship, the date was on 2009. I applied on 5th of February 2010. The merit point system was introduced from 1st January 2011.
That is after you filed the rectified documents.
After I made the application on 5th February 2010, thereafter, my lord, documents were called for from me, which I supplied. Thereafter, as on date, my lord, on consideration, my lord, the consideration of my application upon all the documents been given to them, my lord, as on that date of consideration, merit point system was prevalent. And thereafter, my case was that, my lord, not on the date of my application, merit point system was prevalent.
Then
Not,
what was prevalent, sir?
and thereafter, your lordship, on the date of the review as well, with the review took place, my lord, in 2021, as on
At that time you were age barred.
no, I was not advised because age has to be considered from the date of the application and not from the date of the review of 2021. That was my contention before the tribunal. My lord, kindly see.
Where is the review order?
My lord, the review order My lord, page 110, your lordship. Because, my lord, as per page 110, your lordship kindly comes.
Yes. 110 is only details.
My lord, list, because these are the total, there were 136 candidates, out of which your lordship, my lord,
What you are showing on page 110.
oh, my lord, 112, your lordship, I'm so sorry. My lord, 112.
112.
Yes. So this is the list of the candidates who were.
Where was your dismissal of review?
My lord, the dismissal review was through this list which was published thereafter, wherein my name was not considered on the ground that, my lord, I am my lord, age barred.
Where do we find that? Where do we find that? Page 111 is the review committee resolution.
My lord, 111 is the review committee, my lord, which says that, my lord, that 136 candidates whose application was reviewed by this, my lord, minutes. My candidature was not considered. Even, my lord, in the review, there were candidates whose age was considered from the date of application only, and they were allowed.
Where have you made out that case, sir?
My lord, I made out that case.
Where do we find? Page 111, it says 10 cases were not recommended for due to crossing of maximum age for engagement to the post of GDS. Your age for the, forget about initial consideration and review.
My lord.
There is a fixed age for appointment.
My lord, that is 18 to 40.
You were within the age on the date of the first application.
Application.
So by the time it came to be considered, it was found your age bar.
In 2013, I was within the age, the first date of consideration, wherein, my lord, I was rejected on the merit point system, 2013, and thereafter by the review, which took place in 2021, as on that date of review, I was beyond 40. But my because there were, my lord, I mentioned the name of the candidates as well, the serial numbers, whose age was considered from the date of their application and not from the date of the review.
How did the tribunal deal with that argument?
My lord, they did not.
No, was it, did you file any reply? Did they file any reply
No.
to the original application?
My lord, original application, they filed reply.
Where is that? Have you annexed that here?
Only
No,
the
my lord, that
OA
was
has
not-
been annexed, the
My
reply
lord,
has
only
been-
OA has been annexed, your lordship.
Not the
Do you
reply.
know there was any reply rejoinder?
My lord, grant me 1 minute, my lord, I'm just checking.
I don't think there was any, because it was. Yes, you file your opposition to.
Yes, your lordship, there is an affidavit in reply. That means they have filed their opposition. My lord, reply has been given by them. Yes, এই তো। দিয়েছে। আচ্ছা। যদি একবার দেখো, ওইটা আমাকে দিতে হবে।
Subsisting scheme on the date of appointment.
We will file a opposition, your lordship.
But madam, you have not challenged this finding of the tribunal. Tribunal said that you consider on the basis of the scheme which was prevalent.
Your lordship, we have considered on the basis of the scheme and we have rejected it, stating that.
Then you have to show us your scheme.
Your lordship.
Because on the date the scheme came, if there is no rider to the effect that all undisposed of cases will be governed by the scheme, then you cannot make that scheme applicable.
My lord.
We will deal with in an affidavit, your lordship.
96 page 96.
9th March 2012.
Yes, considerable.
So where is the where the discrimination point has been made out?
My lord, the discrimination point has been made out, your
They
lordship.
have considered it on the
Para
basis,
29 I have stated, your
they
lordship.
have considered it on the basis of which scheme?
My lord, on the review they have
Forget about review. Your initial case was you have not considered by the provisions which were prevailing on the date of death.
yes, your
This is
lordship.
your primary
Yes.
argument.
No,
Then
my primary contention was that, my lord, I was discarded on the basis of merit point system, which was not prevalent as on the death of my father.
what
As
was prevalent then?
that,
Show us.
my lord.
Your Lordship, it was a defective application. After the defects were cleared, GDS was applicable, which we have made applicable.
For amendment, the police gets back to the date of filing.
My lord.
So the present writ petition has been preferred challenging an order dated 22nd of March 2023, passed by the learned tribunal in the original application being OA 350 stroke 01797 stroke 2016. Hardly learned advocate appearing for the petitioner, the learned advocate appearing for the respondents, prays for leave to file an affidavit in opposition.
দেখে নেবো।
Let such affidavit in opposition be filed within 2 weeks. Reply thereto if any be filed. In 2 weeks after the vacation, this the matter under the same heading in the combined monthly stop. Yes.
July. Deeply obliged.
Obliged.
I have challenged the order of passed by the tribunal, page 193. Book. 190.
Yes.
So far, my lord, the point score. Your lordship kindly take the trouble of looking into page 196, para 5.4.
Yes.
The merit point awarded to the applicant was 38. So, my lord, in this whole judgment, there is no attributes. How he,
Please take the mic. Please take the mic. Mic.
my lord, how he arrived at 38. No attributes has been given. The person got 60, he appointed, what is his attributes, that is also not given.
That is not required. You are
Because my lord, my father died at the age of 54. And my lord, 6 years service was left. And my lord,
that was not your argument before the tribunal.
that was not written. That is the whole issue. And my lord, the issue is with regard to compassionate appointment, considering the aspect, my only flat, I have sold the property because my father was ill and he was a cancer patient. And my lord, the entire liability has not been taken in part. Where the CRC meeting has been held, only assets have been shown. The liabilities portion never shown.
Come to know. You are not shown, you said.
My lord, I praise that in the original application, I have categorically stated that I sold my flat because of my ailing parents. And my lord, that is why the compassionate appointment is, my lord, prayed before your lordship, the compassion to be shown. My lord, here it is, I have shown 38 marks, and that is also not given how it is arrived. And my lord,
your case before the tribunal was that you have given persons who have secured less marks than me.
That is the whole issue. The less marks.
The tribunal has decided.
My lord, that is why I have come before your lordship. How I have come to 38. That is
was not your case, sir.
My lord, your lordship
The
kindly see.
tribunal. You're now the first it was said it will be under 2018 vacancies considered.
Yes.
You got 38. Now you had again considered under the 2019 vacancy.
No, not yet.
You have not yet been considered.
Not yet been considered. And my lord, in the order sheet, your lordship kindly see, it is said in page, internal page 190, para 6.
Has your next meeting been conducted?
Yes, my lord.
Next meeting has been conducted, where you will be considering his claim afresh.
Oh, my lord. Lord, one meeting may be held, Lord, because two meetings are over. Lord, his client has not been, Lord, through in the last two meetings. One meeting may be held, Lord, within a short time. বেনিফিট পেয়ে গেছে কোন বেনিফিট ডেথ বেনিফিট পেয়ে গেছে তো অনেকদিন
5.10. 5.1.
Then you meeting of the vacancy of 2019. It has been over.
It has not been declared because it has taken some year. So 4 years, 2019 vacancy, and it is 2024. That CRC has not sat on 2000.
Page 6 of the order, Mr. Roy.
Yes,
Mr. Roy has got the brief also.
In fact, I thought the brief is with yes.
Now we can evidently disclosing that, Mr. Raj.
Internal page 6. Stop.
In pursuance of the order dated 2nd December 2021, passed by the Honorable.
No, internal page 6 of the order. 5.10. Para 5.10.
5.10. এটাই তো দেখছি 5.9 5.10
5.8, internal page 6.
internal spacing. Yes, the case will be placed before the next CRC meeting for the vacancy year 2019, which is expected to be held shortly. That is my
Disclose in your affidavit then.
whether meeting has been held or not.
And you deal with your abatements also.
All right.
Hard, Mr. Mr. Royal London will be appealing for the respondents. If you file an affidavit in opposition, let such affidavit in opposition be filed within
38 pages.
2 weeks after the vacation. 2 weeks after.
2 weeks after vacation.
Reply thereto if any be filed within a week thereafter. This the matter for final hearing under the same heading in the combined monthly list of July.
July. Monthly list of July. I am grateful to.
The petition before Lordship. The petition before Lordship was a medical officer. Is a medical officer appointed the Constable Relay Medical Works of my lord. She was appointed on 2nd of February 2015.
Then what happened on 4th October, Mr. Samanto?
4th October, my lord, your lordship, kindly come to the order.
You are wanting expeditious disposal. Challenging the order of 9th August.
9th August, my lord. 9th of August. My lord, on that date, upon service of the application, I wanted to move the application. Upon service of the application, all the respondents, I wanted to move the application. My lord, the learned tribunal, my lord, your lordship, kindly see the order. Learned tribunal says, I have made a prayer for effective further service. But that is not the reality. I served the application upon all the respondents and I made a prayer for concession interim relief. Tribunal recorded that I have made a prayer for effective further service and
It is made clear at this stage, we have not entertained the interim relief as sought for in the way. My lord, it's the court of law, my lord. 4th October.
What interim relief you sought for?
But interim relief, I wanted made a prayer for concession of the representation. If your lordship kindly come, the representation which I made against the transfer, kindly come to my lord the representation, which has not even accepted. Page 26. I am a doctor, I am MD in pediatrics.
26.
Page 26, my lord.
So where is your order of transfer?
My lord, that has
Order of transfer.
my lord, that has not been. That is,
So you have been transferred from where to where?
from Constable to Malda.
Later not received. No.
I made the representation because of the serious illness of my daughter, 14 months older daughter. Well, page 14, page 4 of my application, if you lordship can see. 4 and 5. My application was not accepted, was sought to be frustrated, so that the transfer order may be given effect to.
This was in 2022, Mr. Samanto.
Well, 2022.
So what is the
2023. Yes, 2022, 23rd of March 2022.
So you still did not join the transfer?
I have not been, on the contrary, they have issued a
disciplinary proceeding.
Disciplinary proceeding, what I am praying, your lordship kindly direct the authority, to consummate. Nothing more, nothing less. Let them consummate representation.
You participate in the proceeding and say that.
Let them proceed. I don't mind. But they have to consummate representation. What prevented them to consummate representation?
Must have taken that point in your disciplinary proceeding. Must have taken.
Well, yes.
Their proceeding was that.
Proceeding was challenged. I have challenged
yes, Mr. Banerjee, what is the stage?
Yes, my lord, the disciplinary proceeding has already been initiated.
Yes, that is started.
Has
in order to be posted.
Now the issue remains, my lord, we have issued the charge sheet. My lord, she did not turn up. Again, my lord, we have tried to hand over the same personally. She refused that.
Why didn't you accept his representation, Mr. Banerjee?
My lord,
page 26.
Page 26.
So he gave a representation, my daughter is sick. So you could have accepted that and rejected it.
No, my lord, here.
Page 26, you see, letter not
my lord,
received.
the issue, this is not the representation, my lord. Page 26, prayer for approval of my absence as child care leave.
Yes.
Child care leave, my lord, CCL, what she had prayed for.
That is the date, 24th of March.
But once she has been transferred, she has to join.
Do you have the order of transfer?
Yes, my lord, that is at page 30, my lord, amar kagoje tally korbe.
You did not annex the order.
No, she has annexed. My lord, that is at my lord, page 38 তো নাকি আপনার পেজে দেখুন একটুখানি হ্যাঁ হ্যাঁ তাহলে পেজ 30 হবে পেজে মিলছে না তো
30
এটা তো চার্জ শিট ট্রান্সফার জসেফ চার্জ ট্রান্সফার চাইছেন
নো মিলার পেজ ইন মাই পেজ মিলার 38 টা একবার দেখুন আপনার সাথে ট্যালি
মানে পেজ 28 if your lordship kindly come
that is your
and it's a
representative.
P3 that is the communication made to me
exactly page 38 is the office order
page 28
and page 38 is the office order page 38 milar if you lordship and 39
you are being transferred from Kharagpur to Malda.
Not from Kachrapada.
From Kachrapada to Malda. This was issued on 23rd March
2022.
So on 24th, you submitted a prayer for child care leave. You did not challenge the transfer.
But on that date, because I did not challenge, I made a prayer. Kindly consider my difficulty.
So thereafter, now what is the stage of the proceeding? Have they issued any order against you?
Well, that they have.
Then you could have said that before the tribunal, Mr. Samanto. It appeared on 4th October 2023. Matter was returned.
That is pending before the matter. I am contesting there.
So there
I have
is
been contesting. But my prayer is before Lordship, your Lordship can dispose of the matter, both the matters, with the direction. Let them consider. Let them continue with the proceedings.
Mr. Samanto, you
At least my prayer for consider my prayer, my representation, my difficulty. I'm part of person of the railway service.
So you say it before.
But I said it. They did not even accept the application.
No, what happened on the returnable
No,
date?
respond.
October 2023.
Man,
it
respond
must
number
have appeared before.
Man, respond number 10, respond number 10, who is stationed as constable for 25 years. Same place.
Mr. Samanto,
That is not the
we want
promissory
to
right.
know what had been the further orders in this obligation. Without seeing that, how can we consider your prayer? We don't know. Maybe on the next day, tribunal has said you considered that.
Man, let them take instruction then, my
No, my lord,
your
page
child.
42. Page 42 onwards.
My lord, your lordship, they have initiated.
There is an inquiry and the findings of the inquiry committee is also there.
I
Page
have
43
been
at bottom.
participating, my lord. I have made my
No,
representation.
my lord, she is not participating.
The entire proceeding, entire initiation of the case is under challenge. In the context of Rule 9 of the Railway Service Appeal Dismissal Rules.
Challenge.
My lord is not getting. I do. In our page, my lord, page 42, 43.
You want to cancel the memo of 15th of March 2023. 15th of March 2023 is the most probably the charge sheet, na? Your
Yes.
charge sheet is
13th March. Charge
where-
sheet is of, my lord, 13th March.
Where is that page?
My lord, they have not annexed it. My lord, we have
They have given the date 30.
page 29.
Page 74.
75.
Page 29, my lord, kindly see.
Page 75.
Yes, page 29. আপনার পেজে 75 27
Okay, page 27. Page 27.
অ্যাকচুয়ালি আপনার পেজের সঙ্গে আমার মিলছে না, আমার সাথে জজ সাহেবের মিলছে না।
না না, এটা ঠিক আছে। 27. Page 27.
এই যে যথারীতি মিলছে না আমার 27 এটা দেখাচ্ছে। আর 75 আমার ক্ষেত্রে তো না। পেজ 31 হচ্ছে স্ট্যান্ডার্ড চার্জশিট।
Standard form of charge sheet.
That is 13th March 2023, page 31. তাই তো আপনার ক্ষেত্রে কত 31 ঠিক আছে তো?
So you have challenged the charge sheet, Mr.
That has not been.
I have challenged
No,
it.
no, no.
Then
But the entire
No, no, no.
entire decision proceeding.
you're challenging the original application.
Yes, madam.
The prayer is identical.
No, madam.
Main prayer and interim prayer is the same.
Madam,
You come to page 18 and 65 and 66. Find a simple difference. You
66.
have sought for main relief.
Interim relief, mandatory injunction. Instead of ad interim injunction, mandatory injunction, what is the main prayer?
Yes, yes, madam. 56.
Allow him to join.
Notify.
Well, I challenged that already. I have challenged that.
Interim order always in aid of final relief.
Yes, yes. Yes,
As interim order, you cannot you seek the main relief.
yes. But if the entire action is bad in law,
Interim order shall be passed till your final relief is decided.
my lord,
During that period.
that is true, my lord. If I challenge the initial action,
Mr. Samanto, you have not been instructed by your client because the charge sheet is of 2023. We are in 24.
my lord.
You do not know what the tribunal has done on the next day. You also do not know whether at all the application is surviving or not. Without this data,
No,
how
this
can
is-
we help you?
This has been
Because from
filed.
the order, it appears
No,
that
this
next
has been
date was
filed before lawsuit can see. This has been filed before lawsuit on.
you have filed before us on August 23. It was fixed on October 23. What happened, we don't know. Whether it is surviving or not, we cannot.
No, no, tribunal has not yet heard. Tribunal has not yet heard the application.
Then we have to, we don't have any other.
Well, I have come to your lordship whether the tribunal can ignore my application, intermediate. Whether the tribunal can say.
What interim order you are praying? Tell us.
Before the tribunal.
And before us also. You want
Well, I am tribunal interim order for consideration of my representation.
That is not a subject matter of the list. So what you want your consideration is child care leave. That has nothing to do with this. Mr. Samanto, withdraw, ascertain the stage, and then come back to us if you are in problem.
I have annexed the tribunal application also. Well, your lordship can see what I have prayed for.
Yes, you have prayed for cancellation of the charge sheet.
You
find
you
65
and 66. I have
65 and 66. Your main belief has been
As well as the same, identical.
no difference even in a single word. Find out. A page has been tagged.
It is better if you withdraw, Mr. Samanto. Otherwise, we have to dismiss it.
Made an application with it, or for whatever interim order you want to.
Make an application before the tribunal that after ascertaining the stage, you make application for preponement of hearing or something like that. Then you can come to us say that. But what interim order we will grant you, Mr. Samanto?
Your lordship can page 66, paragraph B. Page 66, paragraph B.
Yes. Now next come to next page, 67, paragraph B.
Yeah, madam, that is the interim, madam, that is interim prayer. Madam, you can kindly see page 60 and prayer B to direct the respondent 3 to consider and decide the representation of the applicant dated 24th of March 2022.
Cannot be an interim order. It cannot be an interim order. You consider the representation cannot be an
interim order. This is not an interim order. This is a mandate I prayed for.
Yes.
It's a mandate I prayed for.
Mandatory order.
Mandatory order.
Now, interim order, what will be the interim order?
Madam, interim order, your lordship kindly see.
You have to make an application before the tribunal also.
Madam, paragraph page 67.
Is still in service.
But interim relief prayer B.
No,
to direct the respondent to consider decide the representation applicant dated 24th of March 2024 cancellation and withdrawal of the order of transfer forthwith.
সেইটাই হচ্ছে স্যার আপনার
That is the prayer I made because of my personal difficulty. Like this application was not accepted. Why shall I go? I am a doctor.
You did not participate in the proceeding.
That is the next part. When I received the application, received the order of transfer, when I was informed, I made a representation.
So that you have to show to the disciplinary authority that my child was sick. How can I go to that place? That can be a defense on your part.
Thereafter, they initially, without considering my representation, without accepting my application,
dismissed you from service.
Initiated review proceeding. That I have challenged. That I have challenged. Rule 9 does not permit so.
Where is that challenge?
Yes.
Dismissed.
My lord.
No.
Rule 9.
Yes, Rule 9 of the Railway Servants Disciplinary Appeal Rules. That is they have initiated disciplinary proceeding in exercise of the power alleging 9(1). 9(1) of that appeal. I have challenged that order of proceeding. That
will be heard by the tribunal. That will be heard by the tribunal. Ashok,
the pendency of the my prayer is, my lord, my humble prayer before lordship, pendency of the application to the tribunal will not prevent the respondent to consider my representation the 24th of March 2022.
You say that before the disciplinary authority.
How can I say they are not accepting my application?
No, my lord, we have she is not appearing.
Their conduct, they will also consider their attitude. If they do not accept my application even, then how can I make that application? I have stated so. You will also kindly see the kindly see page 27. I made it clear. Kindly see page 27. How the receiving counter of the office of the CMS, Chief Medical Officer, Kanjapara, can refuse to accept an open application addressed to the CMS, Chief Medical Superintendent. My letter was verbally refused by Mrs. Sutopa and Mrs. Sao at your office. However, when I asked back my letter, it was already carried by the staff, Jituraj, to Dr. Saraswati Das in front of so many office staff. Asked her how can she refuse to accept application. She started denying the fact that she instructed. Though you are not liable to answer me, but you should be aware of this duplicity and biasness occurring at your office.
That is the main.
I made it clear on the same day.
Main.
Then how can I pay for justice, my lord?
Mr. Samanto, consideration order cannot be passed at the interim stage because your charge sheet is there. আসো লিখে না দিয়ে দেবেন
By this petition, the petitioner has questioned the legality of the order dated 9th August 2023, passed by the London Tribunal in 1030 of 2023. The brief facts which require to be noticed for disposal of this petition is that the petitioner joined the railway Kachapara Railway workshop is declared as medical officer on 7th February 2015. Subsequent thereafter, he was transferred to Alda. The petitioner on receipt of such an order of transfer, the petitioner, by making a representation, sought for a child care leave. The said application has not been received. Renew his prayer by sending a mail, the type code. On 28th March 22. On May 2022, a copy of the charge sheet was served upon the petitioner, which was issued in connection with the disciplinary proceeding. Allegation of misconduct says that brings a certain allegation of misconduct. Hence, challenging the statement copy of the charge sheets and seeking a direction upon the respondent to consider his representation dated 24th March 2022 and other direction the respondent allowed to join as medical officer of at Majidapara Railway platform and seeking
Release of monthly salary with effect from April 2020. Stop that. Petitioner approach the learned tribunal and original application being in round of the way 1030 the set of original application was taken up for hearing on 9th August 2020. The order would do half the time past 23 or convenience and order taken is quoted very Mr. Amutula submit engineering bill as made before the tribunal on behalf of the petitioner has not been considered and the, although petitioner from the that petitioner having two children is in difficulty to join to his new assignment, but some argument was possible and no finding was returned on the scene. Sought for the and interim order directing the respondent to consider his claims. Mr. Banerjee appealing for the respondent having opposed such care submits that the petitioner is claiming main relief at the interlocutory stage, which cannot be done. So, after checking for the respective parties. As all post scrutiny of the original application, it's clear that the petitioner sought for same relief interim order as well as final order of the original petitioner a service matter to mark the goal to give each respondent to consider his request. It is well accepted principle that interim relief is always past the aid of and no final relief can be shown about and mandatory interlocutor stage. So the relief which was sought for as a main relief before the tribunal cannot be as it we do not find any reason post in the submission of the submission of the business accordingly the petitioner our request clarified that this orders and it is provisions made. Child care.
Yes, next.
My prayer, main prayer was for cancellation of judicial proceeding, and interim relief was making a prayer for concession of representation. These are the two parts I thought to canvass before your lordship.
Yes.
In 9 Miller, I am for the petitioner. And in this matter, this is a order challenged by the petitioner with regard to appointment of assistant audit officer without regularizing the ad hoc accountable. This matter is pending. Yesterday, I informed the advocate for the private respondent that I have some personal difficulty. I may not reach the court tomorrow morning. That's why I informed him that I will be seeking for adjournment today.
Who is your other side?
Mr. C. Sinha is appearing for on behalf of the applicant, the private respondent. I informed that I have some personal difficulty. Today morning, I may not reach. The matter may be next.
Yes.
Good.
Lordship, in this matter, I beg to appear on behalf of the petitioner.
Respondent,
Lordship, this is that matter wherein the petitioner is a casual employee of archaeology.
Kindly see the earlier order. See, pass the order. The learned advocate appearing for the petitioner directed to place before the court in the earlier original application being number such and such on the next date of hearing. And next instruction to Mr. Mukherjee. And lordship, that is the order.
Lordship, specific query was whether they are disengaged on verbally order on the recommendation of a order passed by regional director. So my question is, I have been disengaged without initiating an inquiry.
That is not correct.
And Lordship,
Then what is the other original application?
this is the first round of litigation filed before the tribunal. Lordship, please come to page 32. Page 32 of the original application.
Original application, get it.
Where is this one?
This one.
No, tell us now what
Yes,
happened.
we are
Why
not
two
solved.
original applications?
No, Lordship, it was your Lordship's direction on 12th of December.
Why did we direct?
That whether in the first round of litigation, we have made any prayer to re-engagement of ourselves or not. To that effect,
Now that original application was
not annexed with the
no, that has been disposed of now.
that has been disposed of with a direction before the authority to pass a reasoned order after compliance of natural justice. That reasoned order was passed. Page 72 of this original application. The application under article section 19 of the Administrative Tribunals Act.
This is the order of the tribunal.
Lordship.
22nd of June 2018.
22nd of June
2018.
July.
What have you challenged in this writ petition?
In this writ petition, Lordship, our prayer
13th of January.
13th of January.
Where is that 13th January order?
This is the very beginning, at the very beginning of the writ petition. Certified copy.
7th July 2017. 17th July 2017 order.
Kindly pass the observation of the learned tribunal
July 2017's order is a verbal order on the basis of a recommendation passed by the regional director, that is at page 117 of my writ petition. Since no speaking order was passed, I have challenged.
What was the subject matter of challenge in the original application of 28?
May I short a case, my lordships? May I short a case?
Throughout,
We are not.
our prayer was, we are casual staff.
You have been dismissed without any formal order. This
Yes.
was your grievance.
Yes.
You went to the tribunal.
Yes.
Tribunal said considered their representation.
Yes.
Now, when they considered and again rejected,
Yes.
you preferred the second origin.
Yes.
That has been dismissed.
That has-
Against that order, you have come.
Yes,
So
Lord.
please show us the reasoned order which they passed.
Page 72 of my writ application.
'72 is tribunal's order.
Yes.
Lordship. 75.
Mm.
74 it starts. So this was challenged by the second.
74, Lordship. Reasoned order.
So this was hard on affidavits. This original application was hard on affidavits before the tribunal.
Yes, Lordship.
Have you
Reply and
annexed those?
rejoinder has been filed.
You have annexed those.
Yes, Lordship.
Where is
Reply starts from page 101 and rejoinder starts from page 120.
So you are no longer in service. You have been you have been sent off from since then.
Yes.
So there is no scope for any interim order. The matter has to be
On last
finally heard.
occasion, your Lordship directed the Union of India that since they were disengaged on a verbal order and their daily wages, Lordship, earning 200 or 300 rupees per day,
Hmm.
your Lordship directed to take instruction whether they can be re-engaged or not for the time being.
Yes, sir. What is?
I have taken instruction that there is a casual labor, unskilled casual labor. And this is a policy matter of the government. Unskilled casual labor is not required now. That is a skilled labor is required. On that count, yes, terminated.
Then why did you engage them?
Engage skilled employee, not unskilled employee, skilled employee in place of unskilled employee.
Where is
Casual
their
labor.
government policy?
Yes. যাও না তোমার কাছে আছে তোমার কাছে কি নেই কাগজপত্র থার্ড পার্টি কি এখন সব কথা বলার দরকার Kindly see the synopsis of this case, Lordship. Kindly see first.
Have you annexed that in your reply before the tribunal?
Yes.
This was annexed.
This is that kindly see the reply.
Have you annexed this to your tribunal?
Yes, reply come to the 112. Additional Director General of Administration, Rakesh Singh, Government of India. Actually,
So no further affidavit is required. Whatever you have said, that is on record.
Whatever maybe, that is your. I think the further affidavit is, I fight
Why
to
further
fight.
affidavit? We will fix it for final hearing. Have you been given a copy of this to your friend?
No, no.
No. This was original application. They have filed a reply on the basis of that.
Pursuant to your earlier order.
Lordship, before that, if your Lordship kindly comes, page 117 of my writ application.
117.
Yes, Lordship.
Yes.
Please continue. When you are.
I have made a agitation with regard to engagement of few laborers, and thereafter a inquiry held, and the regional director
117 only got the reply.
subject irregularities in appointment of casual labor at Kalna district such and such, West Bengal, by Sri Arnab Das and Gangadhar Das. Now, Lordship, sir, as per letter such and such, the undersigned visited the Kalna subcircle on 17 June 2017, along with Dr. such and such, Superintending Archaeologist, ASI, Kolkata, and Sri T.K. Basu, stenographer, for an, this is irrelevant, Lordship.
So they have been also directed to be disengaged.
Yes.
In this matter.
Lordship, may I press? Very next page starts with complaints about the duo was made orally by the local MLA. When he came to meet the undersigned at Kalna, the inquiry also hinted towards the suspected involvement of an ex-employee now posted elsewhere of ASI, Kolkata Circle, who investigated the two laborers. The superintending archaeologist, Kolkata Circle, has been advised by the regional director here to immediately discontinue the two casual laborers. On the basis of this recommendation, we have been disengaged. It is not that on the basis of the government circular, we are disengaged. And this circular says, this is of about 2015. No new casual laborers will be engaged. Those who are continuing, their service will not be disturbed. Lordship, kindly come to the language of that circular.
Kindly.
Sir, this has to be heard.
Yes, Lordship. That is true. That is true.
There is no requirement of further affidavit. We are fixing it for hearing.
Obliged.
You have already been discontinued since 2017.
Yes, July 2007.
All right. And kindly see the observation of the learned tribunal. This is
the
then observation of the learned tribunal in this matter. That is very important.
Advocate appearing for the petitioner has placed before us
Affidavit of
copies
service.
of the earlier original application. Let the same copy of the earlier original application. Being this is way how what?
Way number 551 of 2018.
551 of 2018. We have been upon hearing the learned, let the same be kept on. Upon hearing the learned advocates and considering the materials on record, we are of the opinion that there is no scope towards issuance of any interim order. Stop. Next para, we have been informed that the pleadings exchanged by the parties before the learned tribunal had already been annexed to the present writ petition. Stop. In view thereof, is the matter for final hearing in the combined monthly list of July 2020. Yes, next.
এই কাগজটা একটু দেবেন।
Obliged, Lordship.
এই কাগজটা দেবেন যেটা দিয়েছি দর্শক।
Your Lordship, I am for the petitioner in this. Your Lordship,
But I am for the respondent in this matter.
Your Lordship, I am seeking leave to file a supplementary affidavit. I had served my other side on email copy. Served my other side by email.
There is no hard copy.
Served my other side by email. I'll serve a hard copy. If I tried to serve the learned junior of my learned senior, but she said that you should serve at the time of hearing only. This is by email. I had served them, Your Lordship. Your Lordship, I have handed over a copy. Your Lordship.
copy.
My original application, my rejoinder, they did not disclose.
That's what we have filed in the supplementary affidavit, Your Lordship.
Very good. You go through it, Mr. Das.
Your Lordship, Friday the matter may be fixed for Friday, subject to Your Lordship's convenience. Friday the matter.
Motion on Thursday.
Your
In
Lordship.
the supplementary list. Give a copy.
What happened in this matter?
We will hear on that day what happened.
If your loss
IRM and recruitment rules, which will prevail? That is the subject matter of this, Your Lordship. The CAT has held that IRM recruitment rules will prevail. We are of the view that IRM should prevail. This is the subject matter, Your Lordship.
9th supply তে রেখে দিই। আচ্ছা, let the learned advocate appearing Miss Pandey, learned advocate appearing for the petitioners files a supplementary affidavit. Let the same be kept on record. A copy of the same has been handed over to Mr. Das, learned advocate appearing for the respondents in court today. This is the matter for further consideration under the same heading in the daily supplementary list of this court on 9th. Yes.
Your Lordship, in the supplementary affidavit, I also seek leave to add Manoj Kumar and Deepak Kumar, who were in the original application. Inadvertently, they were not made a party. I have served them, Your Lordship, as well.
That you cannot do by a supplementary affidavit. They were before. You have to.
This is the appellate side, Your Lordship. We can do it with the leave of the court, Your Lordship.
Have you served them?
Your Lordship, I have served them. The main application and supplementary both.
For them also.
No,
Your
they are the
Lordship, they
private
are-
respondent.
they
I
are
have
the
challenged their promotion order.
They were the people who were supposed
have
to get the
challenged their
promotion, Your
promotion.
Lordship. They were the law officers on who.
I have secured the better marks. And they have given promotion in favor of the person who has got a lesser mark.
Your Lordship, page supplementary affidavit, page 14 is the original application, Your Lordship.
Supplementary affidavit, you have asked for their addition.
Your Lordship, inadvertently, no, Your Lordship, they were already a part. Your Lordship, they were already a part.
Not maintainable.
Your negligence, you have not taken note of
The writ petition is not maintainable.
Your Lordship, they were already a part in the OA. Page 33 is the cause title of the OA, Your Lordship, in the supplementary affidavit, Your Lordship.
Why you have not included them?
Your Lordship, inadvertently, that was a mistake, Your Lordship. So we are seeking leave, though.
Withdraw the application file.
Lordship, kindly do not. There's such a bulky application again. It's a appellate side rule, Your Lordship, and they are not even. They are the people on whose favor we
will not hear you unless you serve upon them.
Your Lordship, we have already served them. We have already
Without
served them.
making them parties.
Your Lordship,
application.
by filing the supplementary affidavit, I'm seeking leave to add them.
Under the rules you find, supplementary affidavit parties can be added.
Your
We
Lordship,
are not aware.
in the appellate side rules,
Was
by the
the
leave of the court, Your Lordship.
Madam, was the rule that appellate side permits you to add persons as and when you desire.
The civil procedure court will be applicable.
Your Lordship, a contempt application before the CAT, Central Administrative Tribunal, has been maybe filed by them. If this application is withdrawn, Your Lordship,
File tomorrow by making proper
Your Lordship,
parties.
kindly grant me leave, Your Lordship, because this is a Union of India matter, Your Lordship. Entire procedure, again, the permission has to be taken.
Writ petition
They
is
are not
absolutely
even
not
necessary
maintainable.
parties because
They have not made a party. They no
Because-
misjoiner of necessary parties.
Your Lordship, they were in the original application.
What are you appearing for?
I am for the sole I filed an original application
What is
before the
your
learned
sure
tribunal.
of that?
Sure of that.
You are sure of that.
Yeah, I am sure.
You implemented Manoj and Deepak.
Because they have got a lesser marks, promotion order has been issued. Tribunal, after verifying the records, has set aside their order of promotion and directed to publish a press panel. I secured 104.
So they have not assailed this order?
They have
They
not.
did not assail this. Only Southeastern Railway has assailed this order. And my lord, they did not disclose the main notification.
What you have served? Supplementary
Writ petition, supplementary, both I have served, Your Lordship.
Where is your service?
Your Lordship, I'll file a formal affidavit of service, but this is the by email. I had taken the email ID from the department itself and I've served them, Your Lordship.
Today.
Your Lordship, this was served in March. This is the printout is of today, Your Lordship. This has been served on, Your Lordship, on 11th of March 2024, Your Lordship. A printout is taken on 6th May, but served on 11th March 2024, Your
You
Lordship.
have to incorporate them as a
Let
party.
let us hear. Ashok. Ms. Pandil, an advocate appearing for the petitioner, submits that inadvertently the names of two private respondents in the original application have not been incorporated in the cost title of the present petition. Though the copies of the copies of the writ petition have you have filed the supplementary to them.
Your Lordship.
Huh?
I have served them, Your Lordship.
প্রথমে ওটা লেখো মিস পান্ডে লার্নেড প্রথমতে লেখো মিস পান্ডে লার্নেড অ্যাডভোকেট অ্যাপিয়ারিং ফর দি পিটিশনার্স ওই যে কি সাবমিটস দ্যাট ইনঅ্যাডভার্টেন্টলি কি লিখেছো names of two private respondents in the original application have not been incorporated in the cost title of the present release. Stop. Accordingly, next paragraph. Accordingly, she prays for leave to implead the private respondent numbers.
खोलो टाइटल खोलो ना टाइटल खोलो
6 and 7 as party respondents to the present petition. Stop. The learned advocate on record of the petitioners is granted leave to make necessary correction in the cost title of the
Sincerely
present. Ms. Pandey also files a supplementary affidavit with a copy to Mr. Das, learned advocate appearing for the original applicant stroke respondent hearing. Stop. Please the matter for further consideration in the daily supplementary list of this. So, Brihaspatibar the other.
Instead of Thursday, Lordship kindly fix it on Friday. Instead of Thursday, let it be on Friday.
10th is the contempt they are saying. 10th is the contempt.
No.
Oh, contempt me.
Only one day, let it be on Friday.
This matter for further consideration in the daily supplementary list of this court on 14th May. The petitioner, Ms. Pandey, informs us that the copies of the writ petition and the supplementary affidavit have already been served upon the private private respondent number such and such in the original application. However, as no one appears,
6 and 7 in the original applications.
However, next part, as no one appears on behalf of the said respondents, the petitioners are directed to communicate this order to the said respondents and to affirm an affidavit of service on the returnable date. Yes, next.
Next date, 14 May.
14th.
Well, my lord, item number 12, my lord. My lord, on behalf of the Mr. Pathu's appearance with the respondent, my lord. Kindly I bring for after vacation, my lord. He is busy, my lord, for the election purpose.
Please your other side. You are there.
After
next monthly list.
Lordship,
Grateful. No problem.
Lordship, item number 13. Petitioner. Great. Lordship.
Item number 13, my lord. Before I address your lordship humbly, my lord, there are certain knots that I have to entangle myself. Lord, the CRAN number 1, my lord, this is a change brief. I have not got it. I'll have to retrieve it.
He's enjoying an interim order since 2009.
That I
I
am.
have filed a vacating application.
have not been
Application for
served.
you have not accepted it.
No, I have not.
I
been
have.
served.
I,
But
it is
I
come
should
back.
take it here and now.
You take it. I have filed the affidavit of service where it is come back as unclaimed because nobody accepted, no lawyer accepted on your behalf.
This is a change because law has changed.
It's come back unclaimed, so nobody has
But I
filed
shall
for
take
seeking.
service
Lordship,
here and now.
I shall hand him over a copy. But Lordship, there is a urgency in this matter.
Just a minute.
Any
That
day
is-
your lordship's fix it.
Any day.
Next week.
Any
There
day.
is
This
an
week.
interim order.
Yes, since 2009, on the premise that a constable is a Group D staff, the transfer from
But they have also
Kolkata
woken after 15 years.
Kolkata to, no, we haven't. The records could not be found out.
What happened?
It was tagged
Transfer-
with the contempt.
What
Lordship,
remains in the transfer, madam?
Lordship, nothing remains, but we keep getting letters of no coercive action. Even now, Lordship, he didn't accept the brief.
But Ms. Alam, you have not taken any coercive action.
Lordship, he's been sent to the headquarters because there's a perpetual trouble in the administration.
He has
So
not
now the Bhubanesh,
headquarters.
now he's been posted to Delhi. He has not joined. He's been released from there.
That
Lordship, and
order is in
even-
violation of the original order.
But that contempt application.
That original order is
But
Lordship,
let us understand. Now
But-
he is in Delhi.
no.
he is nowhere. He's not coming
I've
to
been
office.
Why
suspended.
didn't you initiate any disciplinary proceedings?
Lordship,
They have not.
now Calcutta has released. He's in Delhi. Delhi, now there is an interim order.
Just show us what vacating application you have. What is the
Lordship, vacating
file? Vacating application?
can one.
Is he drawing salary?
No. They're not paying me salary.
Lordship, since
And after 15 years, they want the application,
Where is the
interim order to be
supplementary-
vacated.
Where is your vacating application?
Lordship, can one? It should be with the record.
রেকর্ডে আছে ছাপিয়েছো? তাহলে ঠিক আছে এই ক্যানটাকে তুমি এই সাপ্লিমেন্টারি লিস্টে দিয়ে দাও। So on 14th it will appear in the supplementary
14th
list.
May, my lord. Lordship.
I'll give you, I'll send you.
We are
But
not,
I'll accept here and now, my lord.
we are
I'll
not
give an
recording
undertaking.
anything, Miss.
Lordship, the affidavit of service which had the unclaimed
Acha,
petition. I can give you the petition from the.
Yeah, you give it from there, but don't
I'll
file
give
that
the
affidavit.
petition from there. No, if you're there to claim it, fine.
Right, I'm here and now. Who's the advocate on recording? You
Because
take it from Chandriki right now.
so Lordship, we couldn't serve it by hand to the advocate.
My lord, the thing
I
is to
sent
be
it-
seen, my lord. After here and now, we accepting.
I'll take it out from here only, Lordship.
She did not file the affidavit of service because I'm accepting it now.
Then let that be recorded, Lordship. Because
Lordship will
I
record
was-
it.
Not passing any order, you give a copy to your friend.
I'll make a
We
copy.
keep it on. It will be there on 15th in the supplementary list under the heading of motion.
Lordship, lordship.
Ajay, the Miss Hard Mr. Imam learned advocate appearing for the petitioner.
My lord.
Petitioner.
Petitioner.
Miss Alam learned advocate appearing for the state.
For the CBI.
Huh?
CBI, Central Bureau of Investigation.
Oh, he's a staff of CBI.
Yes, he is working under the CBI. He's a constable.
Salam
right now.
learned advocate appearing for the respondent numbers 2 and 3. That is Deputy Inspector General and head of the zone CBI.
CBI. Lots of the respondents.
Huh?
Yes.
The respondents.
Who has filed the application?
Application has been filed by on behalf of the Union of India, but the respondents have filed all.
No, this is an application for appropriate order. You have filed.
Vacating, the prayer for vacating the interim.
You have filed.
I have filed.
But this is one Raja Chatterjee has filed.
No, that is the affidavit in opposition probably.
Miss Alam learned advocate appearing for the respondent submits that an application being can such and such for appropriate order has been filed in connection with the present writ petition. Stop. Miss Alam is directed to hand over a copy of the said application to Mr. You have handed over?
I'll have to take it out
And
from here.
directed to hand over a copy of the said application to Mr. Imam in course of this day. Please see matter for further consideration under the heading Motion Central Tribunal on 15th May.
Please.
Voting, my lord, I am appearing for the
I am for
petition.
the response.
That, my lord, in the year 1990, he was appointed as a grade 1 clerk. But in 1994, there is a, my lord, call for suitability test for the post of head clerk. My lord, in that, my lord, call letter, two types of, my lord, post has been called for. One is for, my lord, head clerk, another is for grade 1. My lord, by mistake, my lord, my name was incorporated in grade 2 clerk, and I was called for by that letter for grade 1 promotion. Though I was, my lord, directly recruited as a grade 1, my lord, clerk. My next promotional post is the head clerk.
Mr. Toll, where is the ordered impugned?
My lord, impugned is page 57.
Yeah, give us 5 minutes time. 57. How you have been prejudiced, Mr. Dhol? After all, they say that no junior to you had been granted.
But in 1994, but they have called, my lord, they should have called me for the promotion.
Because you were working as clerk grade 1.
Clerk grade 1. That is their mistake. They have, my lord, admitted, and thereafter, my lord, my lord, my lord, my deprivation will be evident from the fact, my lord, though they have, my lord, corrected their position by a later dated 2/4/1994, that I should be correct, I should be called for, which is at my lord, that is page 8, my lord, that is
Page 8.
page 8.
No, 1994 was the first circular.
First circular.
On the basis of which the suitability test was held.
My lord. My lord, I stand corrected, my lord. That is,
That
my
is
lord,
of
at page 25.
That is sometimes of 2003, I think.
Page 25. My lord, kindly says page 25.
Page 25.
The transfer. The kindly says page 25. It's a handwritten.
Yes. Yes,
Terms of the,
you were called.
I've been called. But Hira, my lord, my
You are Shamul Kumar Hira.
Shamul Kumar Hira, my lord, 2. I was called. But this my lord, letter, though was served on others, I have been deprived of, my lord, getting this letter, which I have specifically mentioned at para 10 of the, my lord, my original application. My lord will find from page 67. I have categorically stated that it was never been served upon me. Page 67, I have, my lord, categorically stated that it was never been served. Thereafter, my lord, I represented to them. My lord,
that was in 2003.
No, my lord. After my representations, this change in, my lord, the gradation list was gradation list occurred. My lord, I was first placed in, my lord, position is at page my lord, placed at 80. Thereafter, my lord, finally I was placed at serial number 21. And that, my lord, my placement as 21. My lord, lastly, my lord, set aside, and I was downgraded to my lord, serial number 53 by a order by a gradation list dated 9/3/2004. That is
Mr. Dhol, ultimately nobody superseded you.
But my lord, because they have in their affidavit in opposition, they have stated there is 49 posts. My lord will find from the gradation list there is 50 posts at that relevant point of time. So, my lord, in multiples of 7, my lord, this candidate is a AC candidate. In multiples of 7, my lord, there will be another post, my lord, which was vacant at that point of time.
But that you did not challenge contemporaneously. This vacancy position you did
I
not.
was not called for at that point of time because I was neither, my lord, I was aware of this, my lord, rectification made by them, and my lord will find from the impugned order itself, my lord, that the persons, that the learned tribunal, my lord, himself itself, my lord, has stated that
expressed dissatisfaction.
Yes.
But what relief do you want?
My lord, I am, my lord, in this application, my lord, I have been, my lord, promoted on 11/2/1998. I was promoted. Along with others, my lord, I have been promoted.
You were promoted on
11/2/1998. Kindly sees my original application.
11/2/98, April, with effect from 97.
I am, my lord, praying with effect from 4/1994 when the others has been, my lord, given the promotion. And because of their mistake, my lord, they cannot take the advantage of their mistake, my lord, by not calling them me.
Then why you are saying that there had been no supersession? Why they are saying that you have never been superseded?
My lord, here is the case. There is, my lord, suppose there is, my lord, they are saying 13 posts, there will be 14 posts. My lord, if there is, my lord, another post.
Where is that document?
Which category?
My lord, I am in SC category.
You are
You
SC.
are in SC.
I am in SC category.
No, the 94 selection was held pertaining to how many posts?
My lord, in the my lord, affidavit, they have disclosed that it is, my lord, it is a post of
Page 23, 13 posts were there.
13 posts were there.
Eh.
But my lord, my reply, lord, kindly see. Yes, my lord, placing before your lordship.
Your reply, your name appearing against serial number 64.
Serial number 53. My lord, my name is, my lord, downgraded to serial number 53 in the last gradation list. My lord, kindly see at page 39. First, my lord, my name is appearing. Page 39, my lord, I draw your lordship. At page 39, Samal Kumar Kira, my lord, is at page serial number 80.
Yes, that was corrected to 53.
And that was, my lord, not corrected to 53. Thereafter, my lord, I have been up, my lord.
After you were promoted, 97 with effect from 97, you were given the promotion.
Lastly, my lord, first they have given my serial number at 21. That is, my lord. After 80, they have placed me in 21. My lord, I will have just placing that at page 42.
That is another aspect. Actually, your claim is that you should have called in 1994. It is your case. Now, in 1994, they are seeking that there was a 13 vacancy, 7 for
Jan 4 for SC and 2 for ST. And from SC category, last candidate from earlier serial number, of serial number 79 of earlier gradation list was called. Your name is again serial number 80.
Now, my lord,
Now you are claiming that there was a 14 vacancy.
my lord,
So you show us, satisfy us.
my humble submission, my lord,
page 25.
if there was
Page 25 বলছে এই গল্পটা সাবসিকুয়েন্টলি
You are called. You are called.
এইটাও জানা ছিল page 25 you were called Mr. Dhol.
Yes.
But that was not disclosed to you.
And now, my lord, they have played a double stand. They are taking a double stand. Firstly, if I am not in the zone of consideration, that is their case. They have made out in the affidavit in order.
Then why did they issue
Why
that?
they issue this? Because, my lord, this shows that they are showing 49, but in calculation, my lord, if my lord sees from the calculations, there was 50 posts. So 15 posts, my lord, 49 to 49, my lord, it comes to my lord, another is 50 after 49, my lord, and another 7 posts will be counted. And if one post is, my lord, exceeds another, my lord, SC candidate, my lord, needs to be considered. And that's why, my lord, they have called me. And now they are taking a, my lord, dual stand that I was not under the zone of consideration, so they have not called me. And they have, my lord, proceeded with the persons who they are called.
But they have
This is only
given,
to cover up the
but they have given the explanation, Mr. Dole. They have given the explanation. Kindly come to paragraph 8 of the order impute. Your case is if 1994 you had been promoted, then there would have been no supersession of your candidature. Your grievance is that I have been superseded due to this infirmity on their part. They ought to have called me in 94, then I could have got the promotion to the head clerk and my position would have been appropriately reflected in the gradation. Their case is that in 1994 there were 13 vacancies. Paragraph 8 said that you do not come within the zone. And that the revision, there was an erroneous incorporation in the gradation list, which was ultimately corrected. And the thing is that you have not been superseded. This fact has been admitted by you. Kindly see paragraph 14. Kindly first read paragraph 8.
What I have admitted is that, my lord, instead of superstition, my lord, kindly whether my lord I cannot explain properly. That's my lord. If a person, my lord, is selected in has to be selected in a particular post in a particular time, my lord, the selection is there is a interest seniority. Maybe there is no other persons who was junior to him was placed in his position, but there is 14 posts he should have been accommodated in that post. So, my lord, my lord, the block 14 is promoted. That is, my lord, that is why I have said that there is no superstition. Superstition arises, my lord, when a person of lower category, lower, my lord, in the gradation list,
he goes against,
is placed upon me. That is not the case. My lord, the case is they have called for every persons who are entitled to, and there is 14 posts. All of us should be, my lord, incorporated.
So where did you state that in your representation? When was your first protest letter? Page 25 you have shown us.
My lord, after my lord, after I have been downgraded, my lord, kindly sees my representation. That is 15/7/2004.
Page. We find 19 December 2003, that is page 51.
My lord, page 50 is my representative.
50.
50.
That is 19th of December.
It is P18.
Hmm. Ninety-four residents. Page 20. No, 94. It's not. উপরটা দেখো 40 পোস্টার এটা তোলা ও না zone of conflict. প্যারাগ্রাফ 8টাতে বলেই দিয়েছে চোদ্দটা ছিল সুপার সেশন জুনিয়র রিজার্ভ ক্যাটাগরি So, Mr. Dole, where have you made out the case that there had been 14 vacancies and not 30?
reply to their, because this is the stand, my lord, they have taken in the opposition. I have, my lord, replied at paragraph 8 of my lord.
So show us their opposition portion where they have said 13 vacancies. Should the 13
paragraph 5.
Yes. Now in reply, what you have stated?
My lord, paragraph 8, my lord, kindly consider.
Your paragraph 8?
My paragraph.
Reply.
Reply. Last portion, my lord, kindly. 8.
Where do we find this? That there were 49 posts in grade 1 in the top of the.
That document, my lord, I have just placed before your lordship, my lord. That is at page 33, my lord, original application.
What is this page 33? 49 posts.
49. They have stated.
But they were filling up 13 out of that.
They are making 13 out of that. But if, my lord, one post is, my lord,
not
no,
included.
There will be, my lord, another reserve vacancy post will be there. My lord,
that would be from scheduled caste.
My lord,
that would be from SC category.
My lord, my lord, of course that be because, my lord, they have considered our case. My lord, that is why, my lord, they have called for. Otherwise, my lord, if their case they have made out here, my lord, that if that is, my lord, taken into account, my lord, I should have been thrown out at the threshold. Why there is a rectification? Maybe that I have been shown in the at the first instance at grade 2. But, my lord, my case should be thrown out because there is no vacancy. You are not coming under the zone of consideration. What they have stated here.
No, their contention is you were initially grade 2, not grade 1.
No, my lord, I am appointed as a grade 1. To RRB, my lord, I have appointed as grade 1. I was never, I held the post of grade 2. My appointment is at grade 1. My lord, kindly see at page 21. Serial number 5. Page 21, serial number 5. My appointment. On 8th of November 1990. Serial number 5, Shamal Kumar Hira. He posted as a clerk grade 1. This is, my lord, my initial appointment through RRB. I was never, my lord, grade 2. And that they have admitted, my lord, that is a mistake on their part. My lord, my contention is now they are taking a stand that there is no vacancy. So, my lord, why they have rectified? Why they have, my lord, allowed me that to come and give the examination for head clerk? Had it been the case that there is no post, my lord, they could have straightway said that yes, though we have made a mistake in calling you, you should not appear before this court. There is no whisper. That instant, my lord, they have called me.
Relation list of which year?
My lord, that in which I have been shown as serial number.
Page 33.
Yes, my lord, that is
They
continuing.
are 51. They are showing the 51.
There, my lord, I have shown as serial number.
No, 70. That is from page 36. That is the relation list of clerk grade 1. But
It is a continuation. First head clerk, then grade 1 clerk, then thereafter grade 2 clerk. And I was being, my lord, shown as a grade 2, grade 1 clerk. I was placed in
serial number 80.
Serial number 8. That is at page 39.
Here it is showing 49. Although last period of last head clerk was 51. Whether 20% post from 20%, 25%.
No, no.
My lord, I have been, my lord, instructed, my lord, as per, my lord, my instruction from my client, that, my lord, for every 7 posts, my lord, there will be a reservation. My lord, that is why, my lord, my lord, there is a calculation, and that calculation, my lord, after 49, my lord, if 1 post is added.
Mr. Dhol, where have you made out that case? Your first representation was in 2003.
2003, because my lord, I came to learn that there was a, my lord, call.
This 13 post, 14 post story, this ought to have been reflected in your representation. You accepted the promotion. In 2000, first, you accepted the promotion with effect from 97. Thereafter, in 2003, you make the first representation.
Because, my lord, I was, my lord, under the impression, my lord, I was.
Moreover, whenever there is a gradation list, objections are invited from employees. Whenever there is a seniority list published, objections are invited.
That objections has been given, my lord, I bow down to your observation, my lord. That objection resulted in, my lord, shifting of the my lord, my position from 80, thereafter 56, thereafter 21, thereafter again 50.
So by this alteration of seniority position, is it your case that any junior of yours has been superseded?
Junior is not superseded, my lord. Junior has not been superseded. I should, my lord.
Superseded you. Superseded you.
No.
That
is.
What is the picture? 94, you were erroneously called according to them. You say that it was their fault. They rightly called me because there ought to have been 14 vacancies. So they have illegally ousted me from that post of which I had no knowledge. Then they considered me in 1997, they gave me the promotion. This induction as head clerk led to transformation of your position in the seniority list. Once it was 21, then it came to 80, then next came to 50. But by virtue of this alteration, Mr. Dhol, can you show us that any person had, you were 21, you were brought down to 50. 53, and then again to 80.
No, my lord, I was 80. 80, I was previous.
So due to such transformation in the seniority list, how you were prejudiced? They are saying that it was an erroneous calculation. That is what the tribunal observed.
I have to, my lord, take a instruction from my client, because this is a, my lord, change plate, my lord, and my advocate on record is also not yet to.
প্রাইভেট জুনিয়র দরকার পড়ে আছে
Yes, what do you say? Anything else, Mr. Dhol?
My lord, I am in dark. That is, my lord, my last part of the representation, last two paragraphs. According to the informed through notification, eight, that my name was wrongly mentioned as group two clerk.
Page 50.
Page, my lord, the representation, last two paragraphs.
Page 50.
Page 50.
Yes.
Last two paragraphs.
But now I have come to know.
Yes, I was quite in dark about the examination held for promotion in grade one head clerk. Thereafter, my lord, I have stated I have never came to know about the examination held in the year 1994 when some of the staff got promotion from grade one to head clerk. This is my grievance.
Yes,
And I
because
was also eligible when I was also
that was 94.
94.
Lord, the claim of the petitioner, my lord, is misconceived. And my lord, he was never, my lord, superseded by any junior, as he claimed at paragraph 5 specifically. But no junior in that case, my lord, has been
Then
made.
why did you change the serial in the seniority list?
No, my lord, it was wrongly, my lord, prepared, and subsequently, my lord, it was corrected, which was recorded in the order of the learned tribunal.
Yes.
Now, Lordship, kindly come to page 23. So it will appear from this Lord office order that 4 posts were reserved for the
Page
23. 4 posts were reserved for the scheduled caste candidates. Now, my lord, selection was made, my lord, in 1:1 basis, and there were at the material time there were 13 posts. And my lord, 13 posts were filled up. Out of these, my lord, 4 scheduled caste candidates were called for interview and they were found to be suitable and they were promoted. Now, my lord, there were other 3 candidates, scheduled caste candidates, over and above the petitioner who were not called for interview. As because 13 posts were filled up by 13 candidates. Lordship kindly
Why
come
did
to
you write this letter at page 25?
25, my lord. This was not written by the divisional personnel officer. It appears to be erroneous. He is not the concerned authority. Lordship kindly see page 24. Who has cancelled corrected the earlier communication? The divisional personnel officer. He, my lord, called for in the interview.
No.
Suitability test. Lordship kindly come to page 24. In partial modification of this office letter, accordingly, one Hiralal was required to be called for suitability test. Well, in his place, my lord, wrongfully, the petitioner was called for. That is why, my lord, the name of the petitioner was directed to be deleted. He never said, the divisional personal officer, who is the concerned authority, he never said while ordering for deletion of the name of the petitioner to call for the petitioner to appear in the suitability test. But this letter issued by appears to have been issued by any subordinate engineer appears to be erroneous. And my lord, petitioner did not come within the zone of consideration as because there were other three scheduled caste candidates who were not above the petitioner, who were not called for the interview.
Where have you stated?
Yes, my lord, it appears from the gradation list. Lordship kindly come to page 37. Page 37. Serial number 28. Serial number 28. N.L. Chaudhuri, scheduled caste. 29. Shambhunath Bagh, scheduled caste. And Lordship kindly come to page 39. Serial number 67. ANC Sarkar, scheduled caste. But they were not, my lord, called for the suitability test. Now, my lord and friend, my lord, are short to say that
They are all SC candidates.
SC candidate. Within bracket, my lord, it was said that the SC
NC Sarkar, the petitioner is the SC candidate.
petitioner is also SC candidate, but
No, after SC Sarkar, Garrison List.
that means, my lord, they were senior, they were not called for the suitability test.
You called H.K. Sinha Roy.
H.K. Sinha Roy was called for suitability test.
H.K. Sinha Roy, which position?
H.K. Sinha Roy.
H.K. Sinha serial 6.
Yes, yes.
But
All
he
our, my
was
lord,
not-
will come appear from page 36. Page
H.K.
36.
Sinha Roy
But-
is SC.
Page 36, my lord.
Is it?
SC Sinha Roy general, maybe general, my lord. G.D. Bhattacharya.
No, H.K. Sinha Roy.
H.K. Sinha Roy is a general candidate. Probably.
Serial 6.
Well, SC candidates are appear, the names of the SC candidate appears from page 37.
H.K. Sinha Roy, clerk.
H.K. Sinha Roy probably, my lord, is general candidate.
He was general, H.K. Sinha.
Probably, my lord, I am saying. No, he is general, my lord. Lordship kindly come to page 23. Page 23, the original list. G.D. Bhattacharya, Ganapati Modak, Kedarnath Sarkar, Jibananand Bhandari, Ashok Kumar De, H.K. Sinha Roy, Sukumar Mitra, Bimal Kumar Rai was SC candidate, Snigdha Das, SC candidate, Vishwanath Mondol, SC candidate, and Sharad Kumar Ram, SC candidate.
SC candidates are
Called for.
Bimal Kumar Rai, Snigdha Das, Vishwanath Mondal, Sharad Kumar Rai.
Now, my lord, the SC candidates at serial number 28, 29, and 67, who were above the petitioner in the gradation list, who were senior to the
Gradation list of whose? This is head clerk gradation list.
No, my lord, it was continuing, lord.
Head clerk, page 33.
এটা grade one. Grade one, এটা start হচ্ছে
From the date of appointment,
33 is 33
33 টা head clerk.
হ্যাঁ সেইটাতেই তো
ডাক যেতে এইখানে
36
The date of birth should be
counted.
Date of birth,
but they were senior, but they were not called for suitability test.
Yes, yes.
45 years. Now,
No, yes. In the gradation list, 67 was
SC candidate,
senior SC candidate.
28 and
Thereafter,
29.
28.
And 29, yes.
28 and
29.
There are two others.
Two others.
Even if one
Even if,
post,
yes, yes, my lord, I am grateful to
is
you.
that post should have been 14 in place of 13,
Yes.
and that post would be 50th post in 50-point roster, and accordingly the state court should have been SC and I should have been called.
My lord, one thing, my lord, probably, my lord, according to, my lord, I just, my lord, cannot, my lord, recollect. Probably, my lord, they have retired. My lord, kindly see the date of birth.
Oh, okay, now they have.
Now retired.
Not now
But
retired.
that
They are-
no,
they are
94
part-
they retired. Date of birth from the date of
45.
birth. But date of birth
45, my lord, kindly see the
45, that means 2015. 45
ঠিক আছে।
plus 60,
এই বোঝা যাচ্ছে
2015.
45
45 plus
HK সিঙ্গা রয় দেখছো
Yes.
28 টা কার
45
28 45 প্রমোশন হচ্ছে 94 65 75 85 না 49 ইয়ার্স হয়ে গেছে তাও তো রিটায়ার 45 এ হচ্ছে ডেট অফ বার্থ 94 এ প্রমোশন এইটা হচ্ছে 94 এর বয়স হবে 49 সার্ভিসে আছে
he was in service.
because 45
94
born 94 selection Mr. Dole.
The my lord, the petitioner wants to, my lord,
Yes.
unsettle the settled position. So he has accepted the selection. He never approached before any court of law, my lord, challenging the selection. In 2003, my lord, he made the representation and thereafter approached the tribunal. Tribunal, my lord, is right in passing the order.
এসো দেবে
এমনি দিনে এসে রোজ দাঁত খেলা আজকে ঠিক
Challenging the order to
page 24 actually that or এইটা দেখাচ্ছে চিঠিটা ও superior officer already previous to that বলে এইটা ইস্যু করেছে দেখো ডিভিশনাল in partial modification of letter Shyamol Kumar Hira has been called to appear but is to be deleted from is to be deleted from junior officer
রোজ এসে দাঁত খেলা এখানেও কি একটা গন্ডগোল আছে এটাও আমার খেয়াল থাকে না কোনো লোক আসতে বলতাম সে
order dated 22nd October 2029, passed in way number 258 of 2005. That's it. Averting to the fact of this case, it will be noticed that the petition
তারিখে আমরা কি করা এখানে ইয়ে করতে পারি আমাদের
petitioner was appointed clerk grade 1.
পরে এসে আমার সাপোর্টে
grade 1 8 is a paragraph 3 of the order fact that yes oh posted at DRM office or
Was grade 1 posted as DRM office on 7th November 1990. A selection process came to be initiated in 1994 for filling out 13 posts of head clerk.
PD circular dated 30/9
PD circular dated 30th March 1990.
সেই সার্কুলারটা পেজ
Out of
20
13 posts,
23 তে পাবে
out of 13 posts, 7 posts
মানে
was undeserved
SC.
Fourth post was reserved for the candidate belonging to SC category
and
the two for SC category.
ST category.
And after completion of the selection, the 13 employees from grade 1 clerk
grade 1.
Clerk grade 1
Were promoted to
was
the post of-
promoted to the post of head clerk.
At that juncture, a letter was issued. The whole argument you to সেটা ওটা argument the petitioner thereafter
Petitioner was promoted in the as in the post of head clerk on 11th February 1998
with effect
from 21st May 1997.
The petitioner thereafter submitted it
On 10th 11th 2003, the petitioner submitted a representation intimating his grievances that in the gradation list here for the head clerks, its position was shown against serial number 21. But subsequently, the said gradation list was reviewed and revised, and he was demoted to the serial number.
He was shown at
He was shown
at serial number 53.
At serial number 3. And he also raised the issue that 1994 he should have called for suitability test held for filling up the post of head clerk.
As we said, the presentation was considered by petitioner.
As the representation was not considered, filed the original application being
which was
upon contested hearing, the original application was disposed of on the reasoning that the no junior of the petitioner superseded him.
Dismissed.
And so, the tribunal expressed its displeasure since such mistake was done while dealing with the gradation list of the staff. Ultimately, state that the petitioners ultimately the tribunal refused to accept the petitioner claim that the petitioners would have been called a selection test held in 1994. Is this the petitioner told us that the hearing for the petitioner submits that the gradation list of the candidates has been prepared and published in a negligent manner. And the Honorable Tribunal has expressed his dissatisfaction.
Even after stop for even after expressing dissatisfaction, the tribunal did not grant.
Even after expressing his dissatisfaction, the tribunal did not grant the petition as well. Drawing our attention to this
The memo dated
to the memo
or to the later dated. Page 25.
Dated 2nd April 1994. He seeks to complain that the petitioner was called to participate in the selection test held in 1994. But somehow the said letter has not seen the light of the day. Not particularly petitioner at that juncture. But at that juncture, petitioner had no knowledge about the said letter. And
It's 20 put the reply.
And the petitioner was not called to participate in the said selection test, since erroneously at that time petitioner was treated as a clerk belonging to grade 2.
Last line to
After submitting that, attention to the garrison list prepared for the post of Flipkart, he submitted that the actual post, vacancy for the post was 50. And hence 14 candidates should have been called
from SC category. From SC category.
From SC, 14 should have been called in place of 13 candidates. And had the respondent correctly make appropriate calculation, then the backing post should have been 14 and the 50th post should have been reserved for the SC candidate, and the petitioner should have been called to participate in the same selection. Since the candidates with the serial number 79 was called, the petitioner should name applicant against serial number 80 was not called. Serial number 70 of the garrison list. But we submit an appropriate direction should be taken so that the petitioner can get promotional benefits with effect from 1992. So, Mr. Samantha opposed such behavior. We submit that there were at least 3 taking us through the garrison list.
Annexed at page 36.
Annexed to page 36. That's 36. Prepare for the case for case 1.
No, 30.
Grade
1.
The garrison list it would be explicit that we have 3 seniors candidates belonging to the SC category are also not called to participate in the selection test.
3 candidates senior to the
candidates senior to the garrison list The candidates and
That three candidates
belonging
to SC category, comma, who were senior to the comma, were also not called for the selection of the year 1990.
yes. But the subject that petitioner did not challenge the selection process of 1994. And he has accepted his promotion awarded to him at the 1998
with effect from
1997.
21/97.
97. And after 5 years, that is in 2003, he made an by representation, he completed his grievances that he should have been to the post, promoted to the next promotional post.
In the year 9.
He submitted as such. They are other than
in this
he was
erroneous to be so there is no their cooperation. अच्छा ठीक है तू तो
English people do that to teach what all participate in the selection process of
admittedly he did not come in the zone of participation.
Admittedly, that should not consideration, but almost the relation list prepared for the post prepared for the choice of grade 1 start grade. It is appearing that there are two other senior candidates.
Scheduled class candidates.
Senior employees who have not been called. So, and it both had more vacancy than
had there been more vacancies than 50.
Exceeding 30.
No.
Exceeding 30.
Still had there been vacancies exceeding 13, even then the petitioner could not have since there were 3 senior SC candidates about the petition.
In the garrison.
In this
in the state constructors. Forcing the submission of Mr. We also do not find to say voluntary interference of the same activity. That is petition. Such is Mr. Yes, Mr. Dole.
May I know the fate, my lord?
Yes.
Yes.
Lord, I appear for the petitioner.
Is your other side, Mr. Bondol?
Subroto Rai appears for the my lord, Union of India. Subroto Rai.
You are not inclined to do it.
My lord,
You are.
I am ready.
inclined.
Yes.
Did he appear earlier?
Yes, he appeared, he filed, my lord, perhaps the affidavit in opposition. I do not know whether it is in record or not.
Affidavit in opposition.
I have been served. I informed him, he left the court.
He has not come.
He has come and left.
Up to date. Yes, next. Affidavit is not here.
Respondent number 5. Respondent number 5. I'm not the answering respondent.
Lordship, item number 16. I appear for the petitioner, Lordship. On the last occasion, Lordship had desired us to give notice because the earlier person who was appearing for the government of Union of India.
I
am appearing.
I'm for the respondent number 5 in this matter.
Lordship, this is my affidavit of service.
Is a case of review of the High Court's order by means of an
May I just
original application.
May I place my case, Lordship? It would apparently
He's
sound.
disturbing him. He's disturbing you. Ignore him. Ignore him.
Lordship, apparently it will sound that my case is a very bad case, but I shall be trying.
Why should we take the
No,
trouble?
your Lordship would kindly hear me. Kindly hear me, because what he is trying to say, it is a fact. It is a fact that the original application, apparently I said, but I said there is something more to the case. Lordship, this is the third occasion before I'm coming before this honorable court. Initially, an application was moved before the learned tribunal, which was dismissed. Against that, I came before the High Court. That was dismissed. I had filed a review application that was also dismissed. I'm very candidly telling your Lordship, 3 occasions the matters were dismissed. But thereafter, I found certain things which were not originally known to my client, on which the review application ought to have been filed.
I see.
Lordship kindly takes up the impugned order. Lordship, may I take your Lordship first to the impugned order?
Yes.
Lordship, I just realized that my affidavit in reply is ready, but for some reason it has not been affirmed.
Yes.
Lordship kindly comes to the order first. I shall take your Lordship first to the order, and then I shall tell you on what ground I am stating that my application ought to have been heard. Lordship, it's at page 93. May I read the order? By this original application, the applicant seeks a direction to the respondents to pay him interest at the rate of 18% on the delayed payment of family pension from the date the same became payable, that is 2/11/82, till the date of actual payment, that is 15/1/1990. The applicant had earlier approached the tribunal by filing OA number so-and-so seeking the same relief. The tribunal held that the claim of the interest does not stand on merit and is also barred by limitation. The OA was dismissed by order dated 9/7/1998. The applicant preferred WPECT so-and-so, which was dismissed by order dated 30/3/2005. The operative part of the order reads as follows. In order to respond to this challenge thrown by the learned counsel claiming interest in favor of the petitioner, learned counsel appearing for the state authorities submitted that there had been no willful laches or intentional inaction on the part of the authority concerned. According to the learned counsel for the state authorities, the delay, if any, was due to the need for taking care of the procedural formalities. It appears that in order to settle such family pension with promptitude, whether it is justified or not, is promptitude, it is necessary for the person concerned also to cooperate with the authorities. Whether it is justified or not is outside the domain of the present litigation. The fact, however, remains that our administration still runs in a conservative fashion. There are many procedural formalities which are required to be taken care of. Lordship, this fact I shall point out to your Lordship is not correct. It's a fact that my client cooperated, and in fact, there was no such procedural formalities which prevented the
Complete.
Lordship. In fact, while settling claims like family pension, the authority concerned insists upon dotting of I's and cutting of T's. In absence of concrete material to the satisfaction of the judicial conscience of the court, in support of the contention that there have been any conscious laches or willful indifference, we do not think that the claim of interest of the present petitioner has any sound rational basis.
You are still enjoying family pension.
No, that is now, I'm supposed to, Amit Ghosh is supposed to get it for a certain period, Lordship, 18 to 21 years. So that, the application preferred a review the applicant preferred a review application. The said review application was dismissed by order so and so. The case of the applicant in brief is that he submitted an application on 4/2/2010 under the Right to Information Act, seeking certain information regarding the grant of family pension. He was furnished certain information with a letter dated 22/2/2010. He was informed that the head of office has no role to play in filling up form number 18, and the accounts officer concerned has the responsibility to fill up items of section 2 of part 2 of form 18, and the accounts officer is not required to make any correspondence with the head of the office. The applicant submitted letter dated 22/5/2010 to the Principal Controller of Accounts, Central Board of Direct Taxes, indicating therein that the information furnished under Right to Information Act shows that the department concerned misled the judiciary, that phony, mischievous, and malicious defense was advanced, and an administration of justice was obstructed. He accordingly requested for payment of interest. The same has been declined with the order dated 19/7/2010. The same is challenged in this OA. The learned counsel for the applicant.
What is 19/7/2010? A requested payment of interest was declined by any order.
Lordship.
In 2010.
Lordship, kindly comes to page 86.
How can it be 2010?
This is the second time. First time denied. First time denied. First OA preferred, my lord.
First time denied when? The
kindly
earlier
comes
OA
to
was
annex.
dismissed on 9 July 1998. Then you made representation 12 years thereafter. In 2010, RTI.
The RTA was much later. RTA, Lordship, kindly comes to page 86. This is the decline. This is the order that was sent to me. You have claimed again interest on delayed payment on part of your family pension through though such delay was not attributable to this office as already admitted. Page 86 of the application, annexure P10. Your Lordship was asking me about 19/7/2010. You have claimed again interest on delayed payment of part of your family pension through though such delay was not attributable to this office as already admitted and decided by courts of law arising out of your lawsuits, apart from the fact that there is no such provision in CCS Pensions Rules 1972 for payment of interest as in your case. Being the party through the lawsuits, you are well aware of the decisions of the court of law. So payment of interest as claimed does not arise. Bishop, I'm coming back to the order at page 94. The learned counsel for the applicant has been heard. It is evident from what has been discussed above that the applicant in effect is seeking a review of the decision of the orders passed by the tribunal, which has been upheld by the Honorable High Court on the ground that the respondents did not disclose the correct information before the tribunal, Honorable High Court, in the earlier round of litigation. The earlier order of the tribunal has merged in the decision of the Honorable High Court. Even if the contention raised by the applicant is true, then the tribunal cannot go into the correctness of the order passed by the Honorable High Court. The tribunal accordingly lacks jurisdiction to proceed in the matter. The OA is accordingly not maintainable and is dismissed at the threshold. Copies of the OA are returned to the applicant. I had the temerity to come before your lordships because the tribunal said that the matter can only be taken up by the Honorable High Court because the order of the tribunal has merged with the order of the Honorable High Court.
Yes.
Lordship, there is one particular
So
difficulty
you have come up seeking review of which order?
Lordship, the review of the original order of the tribunal was moved before the Honorable High Court. It was dismissed against the order of the High Court. I had filed a review application before the Honorable High Court itself. That was also dismissed.
Now, you preferred after the High Court dismissed WPCT 67 of 99.
No, Lordship, that is not the first round of litigation. This particular OA arises out of a dismissal of the
this OA application, the order which you have placed just now. No. Your first application was first original application was OA 930 of 96. That was dismissed on 9th of July 98. Against that, you came to High Court. High Court dismissed the same. Then you went back to the tribunal and sought for review of the order.
No, Lordship.
Kindly come to paragraph 4.
Paragraph 4 of Lordship.
Of your order, which you are placing. So, High Court dismissed it on 30th of March 2005, paragraph 3.
Lordship.
Now, then, applicant preferred a review 1735. This is before High Court or before the tribunal?
Before High Court.
So, where is that order? That you have annexed 16th of May 2003.
Lordship, page 64. It was part of the OA application. Has the OA application been annexed? Yes, it has been annexed. Lordship, kindly comes to pick.
Original application.
But the annex was the original.
No, this is
It is original.
is
16th May
WPCT
2018
9th of July 98.
Lordship, I do not know whether the original application is before the
No, tell us now, Ms. Mitro, that
order.
your first application, 9th of July 98, your first OA was dismissed.
Yes.
Then against that, you preferred the High Court, WPCT 67 of 99.
7 of 1999.
So that was dismissed on 30th March 2005.
Lordship, against that, a review was preferred.
Review was preferred, which was dismissed on 16th of
May 2008.
Lordship, I have that order. 2008.
Acha, ঠিক আছে, 2008. Then after that, what did you do?
I went back to the tribunal.
For what? For filing a fresh original application.
Lordship.
Now, next day, the doors were closed, Ms. Mitro.
Lordship.
Now you went back to the tribunal and filed a fresh OA. What is the case? What is that OA number?
120.
Lordship,
that is 120 of
2011.
Now the fresh issue was agitated. Now he accordingly did.
Because he said that in the review, Lordship, he went to the Right to Information Act.
19th of July 2010. What is that order? This fresh original app. No. What any?
Lordship, may I prepare a list of dates?
No. Paragraph 5. Your patient is already dead. You want to exhume the body.
No.
So please tell us. Paragraph 5, kindly see. Case of the now. You approach tribunal with a fresh application.
Lordship.
Now that was dismissed on 19th of July 2010.
Lordship.
The same is challenged. এটা কি করে হলো বলো তো এটা? The case
same
of
is
the
challenged.
submitted 4/2/2010 সবকিছু হয়ে যাওয়ার পরেও আবার একটা RTI করবে।
Yes, Lordship, that is exactly the fact. I filed an RTI application. There I came to know certain things.
জানানোর পর সেটা জেনেও ডিসমিস করলো 19 জুলাই।
Lordship, can I just
The
get
learned council has been এরপরে কি হলো? The same is challenge, that's all. Oh. Civilian না তাহলে রিভিউয়ের গল্প আসছে কোত্থেকে? এখন তো ও এই অর্ডারটা চ্যালেঞ্জ করছে আমাদের কাছে।
after 2010, Lordship, may I just make one point clear?
Let us understand. So that original application which you filed after dismissal of review was dismissed on 19 July 2010, challenging that order.
Lordship, Lordship, that is probably
Where is this 19 July 2010 order?
Lordship, 19 July, actually,
Page
there was a request for the applicant for taking action in the, it's a letter which we had written for taking action in the perspective of what has been found under the RTI. It was rejected by the senior accounts officer. That is why we came to court. 19th is no order passed, Your Lordship. Lordship, actually, what would have made things a lot easier is if I could have placed the OA
From
application,
what
which has a
discussed, in effect is seeking a review of the decision of the order passed by the General Assembly. ওইটাতে চলে গেল এই অর্ডারের এই 19 প্রত্যেক
Lordship, if I could make a list of dates, I think things would have been a lot easier for Your Lordship.
Was the ফোন করলো যে আমাদের সেইটা যদি সেই ইস্যুটা সেই ইস্যুটা
হাইকোর্টের অর্ডারটা তার আগে কত পেজ করছে 52
Lordship, may I just give Lordship kindly RTI application, at least, Lordship, what I came to know from the RTI application.
The present petition has been preferred. কোনটা এটাই তুমি পোস্ট করেছে এখানে there was no willful lapses or intentional action.
After I got the information from RTI, I decided to file a new OA application, which is the present OA application.
How can that be done, Mr.? Your ultimate issue remains the same, na? That this delay is attributable to them, give me interest.
Lordship,
Now,
it's
this
delay is not, I'm saying that the delay was not attributable to the writ petitioner. Lordship, it was what the government has taken.
But that the High Court has said that yes, delay is attributable, no delay is attributable to the respondent.
Lordship, that is what I wanted to clarify, that there was, in fact, my client was very vigilant. He's one of those persons who is extra vigilant.
Maybe, but if the attributability of
7.
7-0.
7-0.
Winner quit.
That is the order of Justice Talukdar.
So this issue was raised, appearing for the state attorney submitted that there had been no willful lapses, intentional inaction on the part of the authority.
Lordship, that is what I wanted to tell your Lordship is not a fact, Lordship.
But that how can you
Oh.
agitate?
We cannot question the decision taken on fact in earlier litigation. That it is already binding upon both of you.
Ashok, the present writ petition has been preferred challenging an order dated 18th of March 2011, passed in an original application being OA 120 of 2011. Records reveal that the petitioner initially preferred an original application seeking a direction upon the respondents to pay him interest at the rate of 18% on the delayed payment of family pension from the date the same became payable, that is 2nd November 82, till the date of actual payment, that is 15th January 1990. Go for. Prior thereto, the petitioner preferred an original application being OA 930 of 96, seeking the same relief, which was dismissed by an order dated 9 July 1998. Challenging the said order, the petitioner preferred a writ petition being WPCT 67 of 99, which was dismissed by an order dated 30th March 2005. Aggrieved thereby, the petitioner preferred a review application being RVW 1737 of 2005, which was dismissed by an order of 16 May 2008. About 2 years thereafter, the petitioner again submitted an application under the Right to Information Act 2005 on 4th February 2010. Stop. In response thereto,
I received the Lordship. May I give
ultimately the authorities communicated to the petitioner a memo dated 19 July 2010, stating inter alia, এটা page 90, page কততে আছে বলতে যে? Stating inter alia that the delay towards disbursement of the family pension is not attributable to the respondents. Aggrieved by the said communication, the petitioner preferred the original application being OA 120 of 2011 and the order passed in the same on 18th of March 2011 has been impugned in the present petition. Ms. Mitro, learned advocate appearing for the petitioner, argues that the reply which has come from the authorities on the basis of an application made under the RTI Act, reply which has come from the authorities on 19th of July 2010 in response to an application filed under the RTI Act clearly reveals that the petitioner was not in any manner involved towards the delay which had occurred, and the respondents are under an obligation to pay interest for the said delay which is attributable to them. The learned tribunal misdirected itself. The learned tribunal glossed over such argument as advanced and did not return any finding on the said issue. Stop. Such infirmity warrants interference of this court. Mr. Dasgupta, learned advocate appearing for the respondents, vehemently opposes the submissions of Mr. Mitro and submits that the present application is a clear instance of abuse of the process of court, and the same should be dismissed with exemplary costs.
That is a very hard word.
He submits that the issue agitated in the present application has already been finally determined by a coordinate bench of this court, and a review application preferred thereto had also been dismissed. And a closed issue has been sought to be re-agitated. We have heard the learned in reply, Ms. Mitro, however, submits that family pension pensionary benefits are rights at the hands of the employee and are no longer a mere bounty. In the said conspectus, the authorities ought to have granted interest, since interest is not a penalty but a simple accreditation on capital. We have heard the learned advocates appearing for the respective parties and considered the materials on record. The argument as advanced by Ms. Mitro, indisputably, the issue of alleged delay towards disbursement of finally pension had already been decided by a coordinate bench of this court in a writ petition being WPCT 67 of 99. The review application preferred against the same had also been dismissed, and as such, the learned tribunal had no jurisdiction to enter into an issue which has been finally settled by the honorable in a writ petition filed earlier. In view thereof, we are of the opinion that no interference is called for in the present writ petition, and the same is accordingly dismissed.
Lordship, sometimes
Affidavit of service file. Okay.
Lordship, it's entertainment.
Pardon?
Your Lordship sometimes need entertainment of this sort.
the cost, I mean.
No, that entertainment wouldn't have been there had we directed imposition of cost towards.
I'm so grateful that
it is matter is pending for so many years in the docket of this court. Yes, next. Yes, 70. একটু অর্ডার শিটটা দেখাবে, একটা ফাইল দিলেই হবে। On personal ground of one of us বলে আমার নামটা দিয়ে দিই। Matter stands released from our list. Let the matter be placed before the honorable justice for assignment before an appropriate order. Yes, next.
My lord, before my learned senior friend submits, my lord, on the last
Before
occasion.
we take up the matter, how can you say? Let us take up the matter.
I apologize, my lord. 18, my lord.
But I am for the petitioner. At the outset, my lord, today I have the difficulty that my brief has not been brought today. It was under the misunderstanding that these matters will be taken up tomorrow. Be that as it may, my lord, your lordship may remember from the file that it was a particular circular was under challenge regarding, my lord, fixation of pay of some employees of postal department who came under Rule 38.
देखिए order
Virtually, my lord, because of my lord, the pay commission, my lord, they neither got any promotion nor any benefit, and imaginary scale was given pursuant to a circular. That circular was challenged before the Punjab and Haryana, my lord, bench of Central Administrative Tribunal. There, my lord, the government lost. Last order, my lord, will see.
Last order দিয়েছিল order record.
You have filed the opposition.
I have filed opposition, my lord, but
Order towards reconstruction.
my lord, some orders have been cited by.
You have the opposition with you.
I have it with me, but I have filed the opposition, my lord.
No, no, there was a direction that the opposition was missing. Now there was reconstruction.
That was also, my lord, reconstruction episode was also done, my lord. Reconstruction হয়েছিল, হ্যাঁ. Yes, my lord, there was a direction that was also complied with, my lord.
But only one thing, your lordship will appreciate, my lord, for 1 minute.
Mr. Banerjee, learned advocate appearing for the petitioner's praise for an accommodation, though Ms. Shah, learned advocate.
My lord, may I submit, my lord? My lord, on the last occasion,
Wait, madam.
my lord,
Learned advocate appearing for all the respondents. No?
all the respondents.
For the respondents is present. So as a last chance, comma, the matter stands adjourned. So please the matter for further consideration in the combined monthly list.
My lord, my lord, even my lord, tomorrow, my lord.
No. Tomorrow we don't take up this list. Yes.
Tribunal hearing, my lord, as per the determination noted, my lord.
My lord, on
There's something
Combined list, Mr. Banerjee.
copy.
July monthly list. Yes. Next. Under the same heading.
Deeply obliged, my lord.
Most of them have retired, my lord. They
Yes,
are suffering
next.
a lot.
Item number 19.
Deeply obliged, my lord.
And for the respondent, madam.
My lord, I am for the petitioner in item number 19 and item number 22. My lord, I am led by Senior Counsel Advocate Shomnath Bose, who was present in court the whole day. However, he has now gone to Apollo.
Day has not yet ended, madam.
My lord, he got a phone call. His mother had an accident and now he has gone to Apollo EM bypass. However, if my lord allows, I would want to item number 19, my lord.
Item 19 and
Item 19 and 22, my lord. If my lord allows, I would want to reintroduce item number 19, which is the Boshanto Pal case, move the matter, and then my senior, my counsel, would come on the next day and apprise the same.
that won't be possible. Okay. 19 and 22, Mr.
19,
Sen, you are in
22, I am not there.
22, Mr. An adjournment has been prayed for. Dekhiye to 19.
My lord, could the matter be fixed on any other date before vacation?
Come in the next monthly list, madam.
Yes.
My lord, is there any provision that the matter be fixed before the
No,
summer
19,
vacations?
let it appear in the next monthly list, then you try your luck. Yes, next.
Obliged, my lord.
Next monthly list.
Next month.
22 also, my lord.
And I am for the petitioner, my lord, in this matter.
No, I am for the respondent, my lord. My lord, all the papers I have changed brief, my lord. So all the papers.
So let us see now what is the matter. We may dismiss the matter.
Yes. I requested Mr. Chakraborty to supply some documents. He
It
agreed.
will, that is your, we cannot, this will go in the monthly list of July.
But the
Your order sheet to the, why do you people incorporate then take time? Will miss your chance.
yes, advocate is my lord.
You are for the petitioner.
I am for the petition.
Mr. Dasgupta. You
So
are Mr.
Dasgupta was the PT
No,
for the Union of India. Railway.
appearing.
I am Ashok Bhomik, my lord.
Mr. Bhumik learned.
This is first time I am appearing, my lord.
Mr. Bhumik learned advocate appearing. An adjournment has.
I will hand over my lord by tomorrow or day after tomorrow, my lord.
This cannot be-
Papers. My lord, he is retiring in July, my lord.
Who is retiring?
Petitioner. I am for the petitioner, my lord. So, my lord, lawsuits can give
What
any
seniority?
seniority I got.
Then what
I
is
have
the-
been promoted,
got.
but only my lord, pay fixation, pay parity with my junior. That is.
Come in June. Next monthly list, yes.
That will, my lord,
July he is retiring, my lord. Let it remain in position, my lord. It's June is same position. Ma'am, may I file the affidavits I have already prepared?
Opposition.
Opposition, no, no,
Reply
not
they have
opposition,
filed.
reply.
They have
Reply
filed the
supplement.
opposition.
They
Now
also,
on that date, we will take it on record. We'll take it on record on that day and finish it.
record that he has paid for adjournment, my lord, that day. Mr. Ye.
We are ready to hear Mr. Chakraborty. You can argue. We don't have any problem.
আপনি জজ সাহেব যা বলবেন আপনি আর্মি করতে চান আপনি করুন
Yes, next.
Dada, kache time?
21.
Yes, madam, I am for that.
আচ্ছা ওই অভিজিৎ ওইটাতে ওই বিদ্রোহ ছিল না ওটা এভিডেভিট অফ সার্ভিস একটা ছিল
Last occasion you lost it directed that the present name of the present incumbent should be included.
Pardon?
As a contempt not respondent. Because they are not complying the order of this honorable court, that is why. Because I have come before this honorable court, my lord, against the order of the learned tribunal, whereby the learned tribunal, without giving any reason, dismissed my contempt application. Took the plea that within period of 1 year, contempt application was not filed.
What was the parent order?
Mercy, my lord, I have annexed the parent order.
Who is opposing you, Mr. Mojumdar? Who is opposing you?
My learned friend was there. His name, all along he appeared. অমিতাভ নায়ক আর আনন্দ ভট্টাচার্য
order was passed on 13 September 2010.
Yes.
Within 2 months from the date of receipt. When they received the copy of the order? When they received the copy of the order of the tribunal, when it was communicated to you?
Yes, my lord, I am coming. My lord, next page 39. They have received my order. 26/11/2010. 39, Annex 35.
1612. 1612.
Yes, 39, Annex 35, 26/11/2010.
2010.
Thereafter, my lord, again I made a representation to the Chief Personnel Officer, page 40. Page 40. Made a representation to the Chief Personnel Officer. They have received on 22nd December 2010.
So, yeah, Mr.
Then I made a representation to the General Manager also.
Mr. Mujumdar, first communication was after first communication, 1 year elapsed. So what is the wrong with this order? Order was passed on 13 September 2010.
Yes, my lord.
Your communication was on 22nd November 2010.
22nd, my lord, Annex P6. 22nd December 2010.
P6, wait.
Thereafter, my lord.
P6 is your demand notice.
Thereafter, my lord, I made a representation on to the chairman, railway board, on 19th on 19th April 2011, annexed, my lord.
That is you are
42.
issuing. You are
42.
issuing one by one. You are issuing. Communication must be at the once. Page 39. তেরো নয় এটা রিসিভ করলো ওরা গিয়ে 6/12 6/12/2010
And last occasion, I also, my lord,
6/12/2000 না না ওকে কমপ্লাই করতে বললো This example with 2 months on receipt of the copy of it. 6/12 থেকে না 6/12/2010 তার মানে 2 মাস থেকে 6/2/2011 আর ফাইল করলে হচ্ছে 2024 বলে বলছি এই অ্যাপ্লিকেশন ফাইল করেছে হচ্ছে 8/10/2012-তে অ্যাপ্লিকেশন Miss Alam, do you appear for railways?
no, my lord, somebody appeared, my lord. Last occasion, your lordship appeared before your lordship.
Nobody is here now, Mr. Mojumdar. What can we do? We can at least ask him as to whether there is a possibility of reconciliation. Contempt application, again, it will go back
No,
20
my lord,
years.
that is why your lordship
That is why we wanted
my
him
lord,
to.
requested my landed friend to consider that.
Yes, where is he? Where is he? Catch hold of him. Catch hold of him and bring him. Otherwise, nothing can be done.
Then not today.
Not today, আবার কোথায় হারিয়ে যাবে?
Then lordship kindly take it tomorrow also. Because just at this stage, my lord, I cannot catch hold of it.
কি করবে? Heard Mr. Mojumdar, learned advocate, appearing for the petitioner. Stop. No one appears today on behalf of the respondents whose presence is required for adjudication of the matter. Records reveal that Mr. Nayak and Mr. Bhattacharya, learned advocates, entered appearance on behalf of the respondent numbers 1 to 8 on an earlier occasion. Stop. In view thereof, is the matter for further consideration. এগুলো যে কনসিডারে রাখতে পারে। Lease the matter, lease the matter for further consideration in the daily supplementary list of this court. Daily supplementary list of this court on 12th June under the heading to be mentioned. Stop. Mr. Mojumdar, stop. The petitioner is directed to immediately communicate this order to all the respondents as well as upon the learned advocates who entered appearance on behalf of the said respondents on the earlier occasion and to file an affidavit of service on the return. This is railway. Railway. এই চক্র এই additional solicitor general কোথায়? Where is Mr. Additional Solicitor General is here?
No, my lord, this gentleman at inter appearance in this matter, that is why, my lord.
All right, let us see. Yes, next.
This order along with my lord notice I will serve.
22 ডাকলাম না 22 not today কবে হবে তাহলে
No, 22 what happened, item number 16 and 22 were similar. So they prayed for an adjournment in 16. কবে করেছি? 19 and 22. Not today we are.
That item 23 call, my lord.
okay thank you
23. My lord, I am for the petitioner lordship, my lord. I am lordship, I am only praying this, my lord. I have prepared the paper book, subject to lordship. My direction, my lord. I am ready to serve the paper book on all the parties.
Why, without filing paper book, why have you included it here?
My lord, that is relative. Lordship kindly grants me leave, my lord, so that I could file within a week, my lord. That I make.
Why didn't you file for so many days?
My lord, lordship.
Monthly list July. Yes, file in the meantime.
Lordship kindly makes it in monthly list of June.
It cannot be. You file it, serve notice, come back in monthly list of July.
I shall file within a week, your lordship, my lord.
Yes, July monthly list. Yes, it cannot be taken upon that. Yes, next item.
This item number 24, Mr. Chittopriya Ghosh is appearing for the petitioner. There is some personal difficulty, has not attended the court. Not today, only not today. It's
July monthly list.
my lord,
yes.
kindly make it not today. My lord, it's a
Not
senior
today, we'll
citizen.
take you to June. In June, we are having 2 weeks after vacation. It will not be reached.
My lord, it's a senior citizen pension matter, my lord.
Yes.
It said heard it out extensively anyway.
What you're saying?
No, lordship will kindly fix it. I mean, it was heard out by your lordships.
Heard out by?
Your lordship sitting in another division bench.
Myself.
Lordship.
Take it all.
But then it was posted for orders after that. The determination changed and the matter could not be taken.
The pensionary matter.
It's a pension. It's a fixation of pay scale. With Mr. Shukanta Chakra.
The affidavits have been exchanged or no affidavit?
Affidavits, lordship, it was in the tribunal, yes. 24th.
Art Mr. Chakraborty. Who is appearing?
Mr. Chittopriya Ghosh, my lord, I think it's a changed brief, my lord. That's why, my lord.
That's why the parties we kept on record.
Yes, affidavits have been exchanged. Affidavits have been exchanged. Lordship.
What is the issue, Ms. Alam?
Lordship, it's relating to a pay fixation.
Entitled to even
a barrack stores of.
So what is the wrong with this order? Verify from service book the pay that was fixed. Fixation has a new one notional increment. Installation. Yes. Please give me. Have you retired? You have
Yes, my
retired.
lord, I don't.
He's retired.
Retired.
It is entitled to increment. Benefit of you shall. So it has been sent
It
to
has
you
been
for
given.
consideration.
He has been given whatever benefits he had, Lordship, the promotion without additional responsibilities, Lordship. I mean, he has been given the promotional scale. But he's asking for a higher scale, but that, Lordship, he's not
For
entitled.
consideration.
Lordship, that they have challenged. That is their challenge, Lordship. It was, Lordship, our order of consideration has been accepted by the tribunal, Lordship. Lordship, sees paragraph 4. Lordship, sees.
So an adjournment has been prayed
Yes,
for on
Lordship,
behalf
that is
of the
not there.
petitioner, though Miss Alam Learned Advocate appearing for the respondent is present. Stop. Miss Alam informs us that affidavits have already been exchanged in the matter. In view thereof, please the matter under the heading list the matter under the heading list the matter in the daily supplementary list of this court under the heading Central Tribunal hearing on 24th May.
24th.
Chalo, dekhe the. Any matter where both sides are here?
27. I'm for the respondent.
Who is your other side?
Milord, I am for the other side, Milord. If I'm playing for not today, Milord. Just not today. I have
No,
my
one
clerk
thing-
has missed to bring the
One
brief.
thing, my lord, it's a transferred brief. I
আচ্ছা,
find
একটা পরেরটা ডাকো।
affidavit in opposition is in.
Just wait. Yes, কত অবধি ডাকলে? Yes, 25 টা দাও। You're in 25? 26. দেখি 25 টা দাও। Oh. On personal ground of one of us, comma, on personal ground of one of us বলে আমার নাম দিয়ে দিও, comma, the matter stands released from our list. So let the matter be placed before the Honorable Chief Justice for assignment. Yes. 26.
27.
Not here.
27.
Related to promotion.
You are for the petitioner?
My lord.
Petitioner?
Yes, petitioner.
What today?
My lord.
Yes, 27.
My lord, I'm for the respondent. I find the affidavit in opposition is there, but it has been described as affidavit in reply. It's a transferred brief. Affidavit in reply.
You want to give a reply?
No, it is opposition, but it has been described as affidavit in reply.
Milord,
It's a transferred brief.
Milord, our appeal challenge. We have filed a read petition, WPCT, Milord, challenging the tribunal's order, Milord. Now, what I could find out, because today, Milord, I apologize. My clerk has missed to bring the brief, Milord. This brief. So, Milord, if your lordship kindly.
Mr. Dotto, you have used an opposition.
Opposition, but it has been described by my.
But he has not used any reply to the same.
No,
Have you
I don't know whether
just been served.
whether it was served by my.
He said just
I
been
don't
served.
know.
Just been served.
I have no knowledge.
Milord,
Dotto learned advocate appearing for the দুজনেই তো দত্ত।
Milord.
No, we can.
learned advocate appearing for the respondent files the affidavit in opposition. So let the same be kept on record. A copy of the same has been handed over to Mr. Dotto, learned advocate appearing for the petitioner in court today. He prays for a short accommodation to use an affidavit in reply to the same. Let such affidavit in reply be filed within 2 weeks after the vacation. What is the issue?
Issue is, my lord, I got 2 promotions.
Is the
I was
matter
not
for
subjected
further
to
hearing
for the.
altogether?
They have reverted
Under
with me.
ওই যেটা বললাম ট্রাইব্যুনাল হিয়ারিং ইন দি ডেইলি সাপ্লিমেন্টারি লিস্ট অফ দিস কোর্ট অন 20 কবে দিয়েছো এটা আগেরটা কবে দিয়েছো রাখলেন
2 weeks after vacation. Milord,
24.
reply within 2 weeks after vacation.
2 weeks after the
It will, would you lordship rather to fix it in the daily supplementary list? Wrong nomenclature has been used.
your advocate on record is here.
Advocate record, it's a transfer brief, my lord.
পরে দিয়ে
Mr. Borun Chatterjee is he is running temperatures left.
ঠিক আছে এখন এইটাতে আমি অ্যাপিয়ার হয়েছি না কপি দিয়েছি না না আগেরটা 24/5 দিয়ে দাও 24th May.
May.
Master.
Develop.
2 weeks.
Around. Oh, yes, around.